Hello, good evening, Apurva ma'am.
Good evening, Gauri.
Hi, ma'am.
Hi.
I will be moderating the session today. And ma'am, we are still waiting for the participants to join. So should I think wait for 5 minutes and then we'll
Sure.
start?
Sure, no problem. We can wait for 5 minutes.
Yes, ma'am. Shall we start, ma'am?
Yes, we can.
Okay, ma'am. Ma'am, I'll just give a quick introduction and then you can proceed with the session. So, good evening, everyone. Welcome to the day 6 of the National Level Workshop, come 1 week Faculty Development Program, organized by Guru Angad Dev Teaching Learning Center, a scheme under Pandit Manmohan Malviya, National Mission on Teachers and Training, Ministry of Education, Government of India, powered by George Pinnell Group, a unit of Arjun Das Gulati Memorial Society. So today on day 6, we have with us Dr. Purva Dikshit, Faculty of Law, Jagran Lake City University, Bhopal. She will be our resource person for today. The topic for the workshop is Alternate Dispute Resolution, day 2. Welcome, ma'am. And ma'am, now you can proceed with the session.
Thank you so much, Gauri, for the warm welcome. I'll quickly start sharing my screen and then we can proceed.
Sure, ma'am.
Please let me know if it's visible.
Yes, ma'am, it's visible.
All right. Good afternoon, everyone. I'm sure you all have been benefit with the previous speakers speaking about various topics over the past few days. Today's topic of discussion would be online dispute resolution, its prospects and way ahead. So now, whenever there's a dispute, the first question which comes to our mind is where to go. I mean, we often see in film movies, I'll take you to court, I'll see you in court, I'll sue you. And these are the common connotations which are usually exchanged by people, right? Whenever they talk about any kind of dispute. But we happen to look away with some other prospects of dispute resolution as well. I am sure in the previous session, the basic aspects of ADR might have been covered, which happens to be the alternate to the basic dispute resolution mechanism. The 5 or 4 mechanisms through which a dispute could be resolved other than litigation happens to be arbitration, negotiation, mediation, conciliation. I'm sure you all are aware about these concepts. I'll quickly guide you through these concepts and then we'll switch over to the concept of ODR. Because as they're interrelated, I think it is necessary for everyone to understand what is the concept of ADR in order to understand what is ODR. Alternate dispute redressal mechanism or methods happen to provide a platform through which people, apart from litigation, can go through dispute resolution mechanisms. Now, you're not knocking the doors of the court under these mechanisms. Certainly, if we talk about arbitration as for example, this kind of liberty, or let's just say party autonomy, which is given in the hands of the parties to the dispute, is not given in any kind of dispute resolution mechanism. I mean, you get to choose in a very normal language, the judge of your dispute as well. Who is going to take a decision on your behalf can also be decided by you, only if subject to both the parties are agreeing. Whereas if you look about mediation, mediation happens to be building a communication bridge between people. Those people who are unable to communicate or talk to themselves on their own. And negotiation happens to be happening directly by one party to another. And whereas if we talk about conciliation, on the other hand, again, we bring a third person who will be assisting us to come to a conclusion. In order, if we look at arbitration, mediation, conciliation, and negotiation, apart from arbitration, the 3 other mechanisms happen to have the decision of the parties to the dispute themselves. Apart from arbitration, as in that process, the arbitrator is only going to take the decision on your behalf, rather for you, and will be giving a binding decision in the form of an arbitral award. Whereas if we talk about the 3 other mechanisms, the decision has to be taken up by the parties themselves, and they form a settlement agreement which makes it binding for both the parties. Now, why are we discussing about ADR in order to understand ODR? Because ADR is a branch which is actually inculcated in the form of ODR only. Let's just basically first walk through the steps of ODR to understand ADR and ODR collectively better. Now, what is ODR? ODR is actually essentially a branch of ADR itself. using technology to facilitate dispute resolution mechanism through negotiation, mediation, arbitration, or a combination of these approaches. Now, when do we say combination? The basic question which jots down in our mind is that, is it possible to have two dispute resolution mechanism to resolve one dispute? Yes, it is possible. People come up with two-tier dispute resolution contracts and agreements, wherein they first see that if one pays, for example, they make it up a med-arb settlement, or let's just say agreement. Now, med-arb means that first will be resolving through mediation. If that does not work out, the second step would be arbitration. And if both the things do not work out, that the parties are free to choose their own set of dispute resolution mechanism. So a combination of any of the ADR techniques, or maybe one of the mechanism only, using it in the technological platform, makes it online dispute resolution mechanism. Now, often referred to as electronic dispute resolution system or resolution mechanism. This online portion specifically involves conducting the process, that is filing and managing the claim online. See, ODR is basically frequently seen as the solution to resolving electronic commerce disputes or internet-related disputes, which are cross-border in nature and can be costly to be dealt with through traditional forms of dispute resolution system. Now, it is no surprise, right? We have been looking about e-commerce since ages. We can't disagree that e-commerce has gained its boon in the past maybe 1 decade, basically, but we cannot deny the presence of e-commerce since a lot of time. So now it is no surprise that most of the existing ODR systems, as well as discussions on ODR, have been singularly focused on electronic commerce. Now, why it is being said? Because if we can recall that if we are buying something online, the dispute resolution mechanism happens to be through the same channel as well. For example, if you buy something on Amazon, just a minor example, you get to file a complaint on Amazon portal itself, right? You do not have to go to the court immediately and directly. You can follow a process through which the dispute can be resolved by talking to their customer care, or maybe talking to their customer care executive, and any mechanism which can be followed. Now, if we talk about eBay, that the commerce website has resolved many disputes through ODR. That is about 60 million disputes per year, and more than 90% of those disputes are resolved without a third-party mediator. For example, what happens is that if the dispute is with the company of a particular customer, they themselves on their own, using the online dispute resolution mechanisms, resolve the dispute. Now, I'll guide you through the basic history of ODR now. Now, ODR has emerged in the 1990s, tandem with the proliferation of e-commerce. Now, why? We can't deny that only and only since the advancement of internet, we can only come up with e-commerce and also with the concept of ODR. Since there would have been no internet, no e-commerce, ODR would have not found its place in the today's world. So at the inception, ODR essentially was online resolution for commerce disputes, following the ADR principle of fitting the forum of the fuss. Now, why do we say that it was only for commerce disputes? Because online, or let's just say e-commercial websites, were the only place wherein these mechanisms for resolving of disputes were fit in. The online forum was particularly well suited to addressing the issue of distance between buyers and sellers, who were often thousands of miles away from time zones apart. For example, if I buy something from Amazon, let's just say US, for somebody who's sitting there in Europe, I am trying to approach a person who is sitting in 3 different time zones. And if I have to adopt any kind of other or normal dispute resolution mechanism, it is going to be a tiresome job and nearly impossible for me. I'm saying nearly impossible because it still has a chance of being possible. So ODR was also appropriate for the size of the disputes, maybe because if there's a delay in delivery, or if there's a damaged product, if the product is not being delivered in the way it should be. All these kind of disputes have been resolved through ODR in the sense that parties can connect with each other in spite of the different time zones, and they can actually resolve the disputes. Now, a quick and easy, low-cost process were essential to the economic model. Because if we talk about, if I am buying something from somebody who's sitting, miles apart from me, I will have to engage a lot of time, money, and effort into it. But if we take a look at ADR or ODR, this is covering all my hassles. It is going to ease out all my things, ease out all my problems, and make it a very hassle-free process for me to actually accommodate that. Now, initial ODR platforms were meant to help two private individuals to resolve a dispute and come to a fair outcome. Now, and primarily used by large companies such as eBay, Amazon, and others. Now, ODR was most valuable if the system itself could guide the parties to a resolution. Why do we say that? Because if the parties, or let's just say the system is not friendly to this kind of mechanism, the entire purpose of having ODR as a dispute resolution mechanism would be failed, and it is not going to lead us anywhere. Now, we are also looking at the part that with customers in geographically distant areas and the potential for increasing number of disputes correlated to business growth. Now, why do you think eBay or any other e-commerce websites were able to bring up this kind of dispute resolution mechanism? Because the kind of people they were dealing with, the number of customers they were dealing with, it was not possible for them to actually come up to one place and call the other party and be there present and resolve the disputes one by one. So large companies have strong financial incentive to resolve disputes and issues without human mediators. And speed and reliability were essential for these small, similar, numerous disputes. So they're saving a lot of time, right? For example, if we have a look about that, I ordered something from eBay and I happened to got a very damaged product and I'm extremely furious about it. How can they resolve it? If I have the normal dispute resolution mechanism, I'll take them to court and maybe hire a lawyer and wait for my hearing until the time the purpose of the product would also be losing. Whereas if we talk about from the party side, the other party side, then from the company side, they're actually utilizing a lot of money, manpower in order to resolve one single dispute. And it is very inevitable to resolve, to avoid any kind of disputes in these kind of times. So it is very essential for them to come up with certain kind of techniques and mechanisms through which disputes can be resolved easily, so that it is actually saving a lot of time and money on their part as well. Though each dispute is very unique and all were commercial and financial in nature, between a buyer and seller, about a discrete number of irrelevant circumstances. In its simplest form, if we talk about, this process consisted of one party filing a complaint online where the other party could see and respond to it. Similarly, what happens right now, for example, if you have to buy something from an e-commerce website and the size does not fit in, you are actually putting a request for return. 2 days later, the return person would be here to pick it up, and this is how it is done. It is saving time. Now, if two parties were unable to come up to an agreement, a mediator could be assigned. If we talk about in normal circumstances as well, it still happens. If you're assigning a return for a product and it is not happening, then you'll get a call from a customer care executive that is acting as a mediator sometimes, who's trying to understand what has happened. And otherwise, in certain situations, no intermediary is also required. And it is not necessary as well, and the dispute can be resolved promptly and without using any kind of human involvement, right? It is an automated system through which a dispute could be resolved very easily as well. Now, ODR is often confused and simply sees an online form of ADR as well, which to a certain extent could be held right as well, because through online dispute resolution mechanism, we're adopting the techniques of ADR only, wherein if we talk about, we can have mediation online, we can have conciliation online, we can have negotiation online through an online platform. Earlier, it was only being used, I'll reiterate what I said, earlier it was being only used for e-commercial, or let's just say e-commerce transactions and dispute. Now, in today's present time, the horizon has actually increased and expanded. It is being used for numerous purposes as well, which we'll be discussing and talking about in the coming time. Now, ADR, I'll quickly be juggling between the two concepts because they're interrelated and it's very pertinent for us to understand. Okay. Now, ADR refers to tools and processes that allows the party to resolve the dispute outside of what is typically considered to be a courtroom and without a magistrate, judge, or other government-provided decision maker. Now, why do we say that? Because, see, what is the charm of actually adopting ADR? The charm is basically that you get to choose your own environment. I mean, I can right now talk to 50 other people right now while sitting in my home, at my comfort zone. And exchange and deliberate on a lot of topics. Similarly happens in mediation or other kind of ADR as well. I get to choose my own place and space wherein I can sit according to my comfort zone and maybe resolve the dispute which is troubling me a lot. And it is not in a very formal set of environment. That is, I do not have to go and stand in front of a courtroom, maybe wait for the judge or the lawyer. It is up to me and the other person and the concerned mediator or arbitrator involved. Right. Now, ADR connotes private parties agreeing to work outside of the traditional adversarial format of the courts. Excuse me. So basically, when we talk about ADR, the consent of both the parties to adopt to this mechanism is a must. If one of the parties is not agreeing to it, for example, if we talk about the arbitration process in general, which is governed by the Arbitration Conciliation Act 1996, it says that Section 7, the arbitration agreement, clearly makes it a point that the consent of both the parties has to be there. Right? If one of the parties is not agreeing to come to conclusion that the dispute has to be resolved through arbitration, it will not be dealt by arbitration. Or let's just say in any other form of dispute resolution mechanism as well. So now parties are actually agreeing to work outside the traditional mode of dispute resolution, such as maybe using techniques like arbitration or mediation. Often, ADR enlists the assistance of a neutral intermediary in the resolution process. Now, why are we constantly talking about these two mechanisms? They go hand in hand, okay? ADR, when used online, becomes ODR. That is how basic it is to understand. Now, early on, ODR was categorized as a form of ADR for disputes arising from an online e-commerce transaction or disputes arising from an issue not involving internet called an offline dispute. Okay. Excuse me. So basically what has happened in the earlier times is that koi bhi dispute which has happened between the parties who have brought the products or who have entered into any kind of transaction which happened on an e-commerce through an e-commerce transaction would only be termed as an ODR, that is the online dispute resolution. Now, where is if we talk about right now, nothing has happened to be termed as offline or online now. Everything is same. Right now, we might be communicating online. People are listening at their place offline. So that is how it is work. Now, the ambit and the horizon, as I said earlier, has increased and expanded. Why do we say that? Because right now, when we talk about, a lot of people might be resolving their disputes while talking to each other, while looking at the screen and trying to negotiate on certain things. The horizon has increased multifolds in the aspect that whenever we see ODR now, it is not only restricted or narrowed down to the online transactions, but it is also enumerated and expanded to the aspect of a lot of people who are not even concerned through online transactions are still using ODR as a mechanism to resolve their dispute. However, it has now become its own distinctive category of dispute resolution mechanism, encompassing a broad array of artificial intelligence capabilities used to resolve a variety of dispute types, originally limited to non-binding out-of-court dispute resolution between private parties. Now, ODR has actually grown to encompass minor criminal cases as well, such as traffic violations, code enforcement violations, online mediations, building resolution of disputes, and of many types, including landlord, tenant, and small claims and domestic disputes as well. In the coming slides, you'll see I have discussed about the nature of disputes and the kinds of disputes which are being settled through ODR these days. Okay, now this happens to be an Italian model of mediation, okay, wherein what happened that if we look about, dispute used to be there. So sorry. A dispute used to be there, which can either go through three ways. Sanction if one of the parties do not turn up for the session, mandatory preliminary session for mediation, or if and a certain minimal fee was also be required. After the preliminary session has happened, parties, if they decide to continue, it will lead up to mediation. And if they do not opt to continue with it, there will be no sanction and they can process through litigation. Whereas on the other hand, if they opt in for mediation, another twofold setup falls up into place, that whether one, they can opt for settlement, and second, they can opt for no settlement and reach out to litigation as well. See, a lot of times we have this doubt at what if we opt for mediation or any kind of a dispute resolution mechanism apart from litigation, and we're not happy with the result which has come out, we're not happy with the outcome of the dispute resolution mechanism, what do? We can obviously go to the other modes of mechanism, but only once one mechanism is over, the process is entirely over. Okay. There are different stages of ODR. Now, when we say about stages, see, they have been essentially the growth and the booming period of all these mechanisms. But in India, as we spoke about that, how internet envisaged the growth of ODR, this is how dispute resolution mechanism online based also grew. Now, the first which ran from, it had 4 phases basically. Now, the first one ran from 1990 to 1996, which was an amateur age, in which electronic solutions were in a test period. Okay. Now, in the ensuing years of 1997 to 1998, that was the second stage, ODR started developing dynamically, and the first commercial web portal that offered services in this area was established. Now, the next phase came from 1999 to 2000, given the favorable period of economic development, especially in the IT services. Many companies in this time frame initiated projects based on electronic dispute resolution mechanism, but a large number no longer operate on the market. Now, in the year 2001, the beginning of the institutional phase, during which an ODR techniques were introduced into institutions such as the coast and administration authorities, began into picture. So right from 1990 to 2001 is the era wherein in 4 different phases, the ODR actually prevailed and reached its own place. Now, when we talk about the legality, I'll talk about the legality of ADR as well as ODR, because as we have said a couple of times, they go hand in hand. Now, the Indian legal framework through the section 89 of CPC promotes the use of ADR between parties. We have had celebrated case of Salem versus a bar association, that wherein repeatedly it has been said that ADR should be adopted and can be adopted for resolving disputes at a number of places. Similarly, Order 10 Rule 1A confers power on the court to direct the parties to a suit to choose any of the ADR methods to settle their disputes. This can also include ODR as well. Now, let's look at some of the specifics. ODR follows the IT Act. Now, you will see how accumulated it is. Now, this ODR mechanism does not run in isolation. Okay, it involves a lot of legislatures and acts and statutes, which we're going to just have a brief look at it in the coming slides. The first and the foremost necessity for ODR is that the parties must unequivocally decide that they are going to resolve the dispute online. And the Arbitration Act specifies that the parties are free to choose the place of hearing that they would like to take it place, and which could be online as well. So now the first main criteria or main parameter for having ODR as a dispute resolution mechanism is that the parties should agree and decide that they want to resolve the disputes online. Okay, and as the Arbitration Constitution Act 1996 gives the freedom and liberty and autonomy to the parties to decide the place of arbitration, that place could also be an online portal. That is what is being mentioned. The IT Act enumerates that the electronic records and signatures can be introduced in evidence and given legal recognition under the Indian legal system. Now, why we are discussing about this? Because it is pertinent and important to note that not only IT Act, not only Arbitration Act, and not only other act, they're not working in isolation. They're giving actually hands and supporting all the other acts, which makes ODR a very legally acceptable mechanism to be resolving disputes. Now, if we'll take a look at the few of the case laws, in the state of Maharashtra versus Dr. Praful B. Desai, the Supreme Court acknowledged the use of video conferencing to record witness statements, and therefore the submissions and the proceedings can take place online. Now, what is the point of actually discussing online transactions, or let's just say maybe the acceptance of electronic records? Because when we talk about taking everything online, which also means that the dispute resolution would be online, and the documents which will be entertained in that kind of dispute resolution would also have to be accepted online. And that kind of acceptance have been given to those statements and documents through the IT Act and through various High Court and Supreme Court judgments as well. We have a number of precedents to actually look up to. Now, for this, ICC, that is International Chamber of Commerce, has laid down certain guidelines which ought to be followed for the uniformity. Now, these include agreeing upon the time zone, format of documents, and other paraphernalia. Now, why we say that ICC happens to be one of the most looking up to, like, the benchmark in when we talk about dispute resolution, it has laid down certain guidelines that, okay, the time zone has to be considered, the format of the documents have to be considered, that is, the parties have to agree on it. It cannot work in isolation, as we were talking about earlier. Now, finally, when the award is declared, award is something, as I said, and you might have also read in the previous sessions as well, that award is something which is given by the arbitrator as a final binding thing, a decision which is given by the arbitrator for both the parties. Now, as per the section 31 of the Arbitration Act, it can be exchanged via emails by sending scanned copies. The original copy can be sent later via post. Now, this completes the procedure, and the only thing left in the enforcement is the enforcement of the award or a decree which can be easily obtained in the court. Now, therefore, the crux of the entire matter is that practicing ODR is perfectly valid in India. Okay, we cannot say when we talk about the legality, it is not being supported. It is being perfectly supported. It is even being used currently by the National Internet Exchange of India for domain name dispute resolution. It is similar to a traditional arbitration, but the only difference is that it is conducted over the internet. Okay, therefore, the law applicable to traditional arbitration is to be applicable on ODR also. Just as ADR is legal in India, so is ODR. Now, there have been instances where parties have decided upon arbitration through emails. That is one of the cases which have been mentioned in this slide, is that Shakti Box Food Limited versus Cola Shipping Company, as well as Trimax International FZD Limited versus Vedanta Alumni. Now, one of the cases I'd like to quote here is that where is the Grid Corporation of Orissa Limited versus AES Corporation. The Supreme Court explicitly mentioned that when an effective consultation can be achieved by resort to electronic media and remote conferencing, it is not necessary that the two persons are required to act in consultation with each other, but necessarily sit together at one place unless it is a requirement of the law or of the dueling of the contract between the parties. So if we look at time and again the judgments and the precedents which have been set up by Supreme Court of India, or let's just say High Court of India, High Court of various states, we will understand that this mechanism is being well accepted and is being well promoted, right? It is not something which is alien or which is very new to us. This is being well accepted mechanism that is being promoted, and the parties through section 89 of CPC are also being pushed and motivated to use this as a mode of dispute resolution. Now, through the Niti government Niti Aayog website, we were able to jot down certain aspects of from 2006 to 2020, how actually ODR has actually evolved and developed. In 2006, National Internet Exchange of India was adopted in domain name disputes resolution policy, which provided the ODR. In 2011, Chennai hosted the 11th Annual International Forum on ODR. In 2017, Ministry of Law and Justice issued a statement to urge the government agencies to resolve disputes through online arbitration. In 2018, Ministry of MSME launched Samadhan Portal to address the delay of payment disputes involving micro and small enterprises. In 2019, EADR Challenge was launched to identify and support ODR startups. Now, 2020 was the year in which major challenges, and let's just say major developments rather, were happening in the ODR field. The Government of India launched Vivad Se Vishwas scheme for the efficient resolution of tax disputes through ODR. Vidhi Center for Legal Policy published a report on mainstreaming of ODR in India. Niti Aayog established a committee under the chairmanship of Justice Retired A.K. Sikri to broad-base the use of ODR in India. Chhattisgarh conducted the first virtual Lok Adalat and provided conciliation services. Department related Parliamentary Standing Committee on Personal Public Grievances, Law and Justice, in their report called for the introduction of technology in arbitration conciliation process as well. So if we take a look at all these things, we are able to understand that how ODR is being set up and actually very well welcomed in the normal procedure as well in our country. The government has taken up a lot of steps and has actually amped up to actually adopt ODR as one of the normal mechanisms to resolve the disputes. Now, what are the prerequisites of ODR? When we talk about prerequisites, that there are certain things which have to be there in order to have an effective ODR. First one I'll say is awareness. Now, why awareness? Many of us, maybe half a decade earlier or maybe a decade earlier, might have not even thought about what would be ODR. And some of us might not be still aware about what ODR actually meant. So the awareness regarding the online dispute resolution mechanism is a must prerequisite for an effective dispute resolution. Now, technological tools. Now, technological tools basically means that person has to be equipped that way that this kind of mechanism can be actually adopted. For example, if a person does not have a proper desktop or a laptop, how can you, or a proper smartphone, how can you ask them, how can you expect them to actually handle ODR or be a part of ODR, right? Now, the next is strong internet, one of the basic requirements, because without online presence, there cannot be an online dispute resolution, right? And then the fourth point happens to be mutual trust. If anybody can put up in the chat box and tell me that why do you think mutual trust is required or is called to be called as a prerequisite of an effective ODR, I'd love to hear your views on that. I'll come back to the point later. I'll give some time for the participants to put their opinions in the chat box. So now, secure channels. Secure channels basically means that, for example, if you're talking right now over the Zoom platform, it has to be a secure platform that I know whatever I'm talking, for any kind of secure platform through which I know whatever I'm talking as a person would not be leaked out or would not be used against me. Similar happens in the process of dispute resolution as well. If the person does not know that what is the process which they're going to follow, and it is not a secure process, maybe whatever they're saying or showcasing through their emotions and in the heat of the moment is being used against them at a later stage. So this kind of security through the channels which they've been using for dispute resolution is a must. Now, why trained professionals? Because whenever we speak about all these kind of mechanism, arbitration, mediation, conciliation, they happen to be different mechanisms through which disputes are resolved. And the people are trained in order to how to actually mediate, how to conciliate the entire matter, and how to actually be an arbitrator. The proper trainings programs which happens. So if a person is not aware about any of the mechanism, how do you think they'll be able to help you in order to engage or in order to resolve the dispute? Now, user-friendly platforms. Now, platforms have to be these friendly or these kind of easy and compatible for a first person or a layman to use, because if they're not able to use these kind of platforms very easily, they're going to back out. They're going to back out in the manner that they'll not be able to accumulate or get to know about it, and they might be a little skeptical. Oh my God, I do not know. This is too technical for me. This is too technical for me to handle. I don't think I'll be able to step into this and carry it forward. So the platforms through which dispute are being resolved has to be user-friendly in the sense that they do not have to be complicated, that you require this code and this mechanism, and then you require OTP, then you require your fingerprint signature, and this and that. It has to be a hassle-free process, because the entire idea of using ODR as a mechanism to resolve the dispute is actually to remove the hassle of the court procedure. And that is why people use this. Okay. The enforceability of outcomes happens to be another parameter for effective ODR. Now, whatever decision I'm coming up, if I do not know the enforceability, as in whether it will be legally binding or not, it is not going to actually turn down to the proper outcome of it. I did ask about, I think I will only explain what about mutual trust. When we talk about ODR or when we talk about any kind of dispute resolution mechanism, mutual trust is something which both the parties need to have. Now, why it is necessary? It is necessary because of the sole reason that parties need to have trust on each other, that yes, they will be trying to resolve the dispute through this mechanism. Also, that whatever information they're being sharing, or whatever information they're passing on to each other is going to be confidential, as well as it is going to be kept for strictly used for the professional purposes. All right. Excuse me. Now, these are the disputes, as I was talking about earlier, through which ADR and ODR is being used globally. Right? For consumer disputes, if we take a look about in the entire world, as recent as disputes related to some other country, consumer disputes are something through in which ODR is being used and ADR is being used very effectively. Insurance claims is another ambit in which ADR and ODR is being used very effectively and efficiently. IPR, which happens to be intellectual property rights and the domain name disputes, as we talked about, something which is being used by the Internet Security Exchange of India as well, that wherein IPR disputes are being handled really well. Now, if we talk about a lot of conventions which are there, Berne Convention, Stockholm Convention, which talks about the cyber crimes and cyber frauds. If we talk about ODR being taken up as a dispute resolution mechanism, it is always and only going to make life easy for all the other parties and maybe the aggrieved parties and the victims of these. Family disputes, if you talk about Section 89 of CPC, right, basically mediation is being the most nudged dispute resolution mechanism. Okay, we all know that in family disputes is the first point, or the first point person is that both the parties rather are being asked to have a consultation. Okay, they're being sent for counseling, that wherein they can talk it out and maybe resolve the dispute and do not go for the divorce ultimately. And believe me, when I say this, a lot of disputes are being resolved then and there itself. If not all, but to a certain extent, these consultations and these counseling and mediations do help in actually stopping the families from breaking or from any kind of separations. E-commerce, obviously, as we talked about earlier as well, happens to be one of the major parameters in which ODR is being used in multifolds. Small cause and small claims disputes, another ambit wherein the ODR are being used collectively and at a very large scale. Small and medium enterprise dispute are also another area wherein these kind of ADR mechanisms are being used globally. Now, ODR tools. What do you think ODR tools could be? These are the mechanisms through which you're actually interacting. Okay. Now, email is an obvious modern method of communication among the tribunal and the parties for filing applications, notices, and the like. Now, it is the fast, inexpensive, essentially instantaneous, free, and provides both the complete electronic record of all the filings and the ability to transmit them in electronic form. Its use, however, is not without some issues. Now, when we speak about email basically is actually the first step. If we talk about an arbitration agreement, or if we talk about any kind of agreement or e-commerce things, the first step of these kind of mechanisms or disputes is that they're happening online, right? And when they happen online, they're actually they're providing us a platform through which we're having a point of maybe dispute. Now, this platform is inexpensive. And when we talk about the major advantages of ODR and ADR, it will happen to not ADR, but ODR. It happens to be that it is very time saving, right? Now, essentially, when it is instantaneous and free because the claims are being filed online without any kind of hassle. First, some arbitral institutions like administrating bodies, for example, AAA, that is the American Arbitration Association, require the parties to agree in writing to a email protocol before an email can be used to directly to send between the parties and to the tribunal. In the absence of such consent, all communication could still be made via email, but must be made directed through the administrator, with the resulting possibility of a significant decrease in the speed of communication. Now, I'll quickly guide you through what are these institutions and what are the kind of ADR we are talking about. So when we talk about arbitration specifically, there are two categories of ADR arbitration. First happens to be ad hoc arbitration, the other happens to be institutional arbitration. So the autonomy in the case of ad hoc arbitration is high. I mean, if I am one of the dispute related parties, so I and the other party will get to choose the arbitrator, the qualification of the arbitrator, the number of the arbitrators, the place of arbitration. If there is any going to be any let's just say challenge on the appointment of arbitrator, how are we going to decide to that challenge, and what will be the language of arbitration, the place of arbitration, maybe if there's any kind of dispute which has happened between the parties, or how the arbitrator can be challenged, everything would be decided by the parties themselves on their own. Whereas if we talk about institutional arbitration, it is just the opposite. I mean, you get to choose the arbitral institutions you're assigning your dispute to, but then all the things, the decisions which were made by you in the case of ad hoc arbitration will be made by the institution in the case of institutional arbitration. For example, it could be CR or AAA or ICC. It could be anybody. So now, depending upon the nature of the dispute which you're submitting, the arbitrators would be impaneled, would be chosen for your dispute, and the fees and everything would be decided by the institution only. Okay, so all these things which you were able to decide, the number of arbitrators, the qualification, does not have to be decided in the case of institutional arbitration, as everything of that sort would be dealt by the particular institution only. Now, even if the parties have consented to directly to their party tribunal email communications under the protocol, all such emails must be copied to both the parties and administrator, and ex parte email communication must be avoided. See now, why this part of communication is being told about? ODR, as we talked about, it is happening online. How do we communicate? We communicate through mails in the online portals. This is the first step. Now, these kind of mails have to be marked in what manner? For example, we have kept the name of American Arbitral Institution. So there are certain protocols and that have to be kept in mind while using this mechanism. Now, hearings by video conferences. This is another tool. Now, in today's world, flat world witnesses can be scattered all over the globe, even if they're located in or near one place. For example, some of you might be sitting in the same city which I am right now, and some of you may be sitting in some different place altogether. But we all are connected through the video platform, online platform. So now also, arbitrator in these kind of situations, mediator in these kind of situations could be anybody, or could be any person who's sitting anywhere and maybe in any part of the world and any part of the country. The consent of the parties is the only thing which is required for an arbitrator to be an arbitrator. Now, the arbitrators with the requisite background and experience may be distant from the location of the hearings agreed upon by the parties. Of course, no one can require the arbitration participants to travel for the hearing site, but this can be expensive and time consuming as well. Travel may only be justified for large cases or important witnesses. Now, sometimes it may happen, but that it is utmost required that people have to meet in person only, right? In those situations, people have to fly down to the particular place to attend the hearings. But if you talk about ODR, hearings through video conferences make it easy for any one of us. Right now, I am telling you, out of 59 people attending this conference, this workshop, it is so convenient for us to actually attend these sessions and gain knowledge. Whereas if we talk about, we had to take academic leaves and take leaves from our particular institutions to join these kind of workshops, it would have been difficult, right? Because we all know we have a crunch of our leaves and everything. A lot of things have to be taken care of. But having been provided with a platform through which you can learn things, you can expand your horizons of knowledge just by communicating to each other through a virtual platform, is a blessing in disguise. So similar happens in the case of ODR as well. It is providing you a platform and an ambit through which the parties to the dispute do not have to be in front of each other physically, but virtually they can be there. Similarly, the arbitrators do not have to fly down from one place to another to arbitrate the entire matter, and same goes with the mediators as well. Fortunately, the ability to use IT to take live testimony from remote locations has been greatly improved in the recent years. See, you and I can't deny the leaps and bounds growth of ODR after the COVID era. Because the term which we used recently, offline to online, we actually shifted everything online in the flash of a second, because we had to. There was no other choice. The proceedings were shifted online, the classes were shifted online, the office was shifted online, everything was happening online. So that is why the connectivity through which people were able to actually involve and engage themselves also increased, and also significantly helped people in order to connect with each other. Now, not too many years ago, it was impossible to take a remote testimony other than by phone. Although no video conferencing predates the internet, its use was complicated and expensive. Excuse me. Now, it is not a very hidden fact that prior to 2-3 years, Zoom did not have this kind of large people accessibility. It was being used, it was being accessed, but by a limited number of people. Like just business houses and corporations were using it, but only for the business purposes. Rather, the usage was very significantly less if we talk about the present times, or if we talk about the past 2-3 years, which has certainly just passed away. With the advent of internet, particularly with increase in the transmission speeds and constant improvement in equipment, together with lower cost for both the service and the equipment, live testimony by video conferences over the internet has become a genuine tool for efficient and cost-effective arbitration. But as if with email, there are precautions, some mandatory and some merely recommended, applicable to video conferencing as well. For example, if we did discuss about that, how there are certain protocols which have to be kept in mind while forwarding an email for the official purposes as well. There have to be certain precautions kept while doing the video conferencing as well. That there has to be, we all know about NDAs, that if these videos are being recorded, these have to be used for professional purposes only and not for any other kind of personal works. Thus, the parties and the tribunal should be aware that the local laws excuse me, regarding the taking of the testimony, particularly from third-party witnesses, can vary by location. Everybody should be operating under the commonly shared expectations regarding the applicable law. Now, do you think ex parte decisions can happen online? Yes, they can happen. Now, to avoid to happen ex parte communication with the tribunal or the possibility of improper witnesses coaching, neither witnesses nor the tribunal should be alone with only one party at any one location. Right? Now, why we are saying that? Because there can be influence. There can be people who can be actually showcased, or they can be actually maybe they can influence the decision of the arbitrator or the tribunal, which can actually give an ex parte decision in the favor of the other party. Now, to protect the confidentiality of the proceedings, the video feed must not be subject to intrusion. If more than 2 locations are in play, a log should be kept as well as a list of the record of who all signed in and who all are in attendance and where they are. It gives us a proper authenticity in order to understand who all the people have joined and from where they have joined. It should not be appearing that the maybe arbitrator and one of the parties of the tribunal people are sitting in at one place only and they're in constant touch. Okay. Now, another tool for ODR is e-briefs. Now, reasoned awards, the arbitral award that states the reasons for the result, are commonplace in international arbitration, right? And more common in domestic arbitration as well. A reasoned award may be a simple, short statement of reasons or something as complicated as a full judicial opinion with findings of facts and conclusions of law. For a tribunal confronted with lengthy briefs and a substantial evidentiary record, preparing a reasoned award and verifying that the parties' positions in the briefs are supported by actual hearing, transcript, or documentary evidence can be no small chore. I know whatever I just read out for you might have been a little difficult for you to understand, but believe me, within few minutes, you'll be able to understand that how e-brief is one of the ODR tools and what it is actually. Now, bouncing between on the briefs on the one hand and the transcript on the as well as multiple evidence binders on the other hand, is time consuming and tedious. On top of this, one must also check the parties' descriptions of the laws against the actual authorities to which they have referred. The solution to everything happens to be e-brief. Now, what is e-brief? It isn't much more than a separable electronic or soft copy of the brief. To be sure, it is that. It is in addition, it also provides the backup documents to which the brief refers and link to the textual references to the documents. Now, whenever we make an electronic file these days, if you remember, we can have links, hyperlinks associated to it, and which can direct us to the proper main relevant document. This is what the work of an e-brief is well. In other words, each reference in an e-brief to the recorder authority is a hot link or which a reader can mouse and click, causing the recorder authority in question to pop up in a separate window. You just click on the particular link, particular tab, and the other document opens up. Instead of creating hefty files, it is actually one file which has the link to separate other files as well. There's no need to go back to the record itself and to dig it out on the legal authority. They're instantly available just by a mouse click. So these were the three tools through which ODR is facilitated at a larger scale and at a very huge ambit. Now, the next part is we are talking about is advantages of ODR. Advantages of ODR and ADR happens to be slight same and slight different as well. See, whenever I used to explain this to students that what is actually the advantage of ADR, it is less time taking. Obviously, it is. It is saving a lot of time, which happens to be the prime most requirement of in today's time. Because you can get everything back, but the time which is gone cannot be received back. So now, whenever we talk about any kind of litigation process, it's a little complicated. You and I will both agree, because we have studied a lot number of laws and we know how this process works. We also know that how actually a lot of complications are involved in the litigation process. We're not denying to its significance or prominence or the relevance of litigation at any point of time, but we're also admitting that how ADR mechanisms are actually helping a way out to a party to actually make way in some other mechanism through which they can get a speedy discourse of their dispute. Now, one of the major essential advantages could be that it avoids jurisdiction issues. How it avoids jurisdiction issues? Because it is actually pertinent to understand that we do not have to see pecuniary jurisdiction, territorial jurisdiction, any of the aspects. If I have a problem with the product which has been sold out to me, excuse me, through Amazon, I will not have to look from where it was bought, where it was sold. I would actually be looking at the Amazon return policy or the exchange policy only, right? Or I will be only contacting the particular person, in spite of the fact that I have to, in the normal course of circumstances, if I buy something from the person sitting in Delhi, I will either have to file a case there or the place where I'm residing in, right? So obviously, jurisdiction issues are being reduced in the case of ODR. Now, cost reduction, as I talked about, is one of the... See, I will not deny on the part that arbitrators' fees are actually high, but slightly if we talk about the cost reduction and other aspects, right? And the aspects that if you have to file a case, if you have to travel, if you have to take out time, it is little cost reduction in the aspect that it takes less amount of money involved in any other kind of mechanisms. You do not have to travel, and it is a speedy process, which happens to be the most economical process time-wise, right? It is very pocket-friendly if we talk about, but time-wise, in the sense that we all know, if you take a look at the Arbitration Conciliation Act, as it was discussed in the previous slides, ADR happening online is called to be ODR. So whatever implications, whatever concepts are being put up or being explained in the Arbitration Conciliation Act also applies on ODR. So it clearly says that one arbitration has to be finished within a span of 12 months, with an extension of 6 months in rare circumstances. So there's a speedy resolution, and there also happens to be a fast track procedure under which within 6 months the award has to be given, right? Now, non-confrontational mechanism. Now, this also happens to be one of the advantages in the sense that you are not waiting for there is the See, I'll tell you, one of the most prime and highlights of ADR processes is that it can also take place in a paper in without meeting to each other, right? How it happens through emails. Maybe sometimes when it is required in a fast track procedure, the parties are agreeing that, okay, we do not need to meet. Maybe whatever documents and evidences are being submitted to the arbitrator. Based upon this, the entire process can be resolved and the dispute can be resolved and we'll be happy with it. If at all any kind of meetings or hearings is required, maybe one or two, we are okay with it. But it has to, majorly has to happen without meeting. That is why it is being called as a fast track procedure. Now, neutral and transparent forum. See, one of the basic parameters of actually taking up this matter to ADR is that the people get to choose the person who's going to take a decision on the dispute. Now, that person is decided by the parties themselves. Eventually, the Arbitration Conciliation Act does not provide a specific set of qualifications that who should be an arbitrator, but it does tell us in its own way that who cannot be an arbitrator. But the only parameter or prime requirement is that the person has to be a third independent and neutral party. Because if the person is not independent and transparent neutral person, the person cannot be an arbitrator or can be removed from the position of an arbitrator. So you, when submitting a dispute to a third neutral person, you get a transparent forum that you will be heard, your points would be heard, and then accordingly a decision will be given in your favor, or maybe not in your favor, but still you will have the relief that you were given a proper chance to actually put forward your points. Now, freedom from geographical location. Many times we avoid any kind of dispute resolution just because it is going to be a task for us to travel. Who is going to take so much of pain to go and sit with the person and meet the person to resolve the dispute, or maybe involve so many people? So freedom from geographical location happens to be an advantage in ODR, because right now I'm sitting in my room and can actually talk to all of you is one of the advantages. Rather, if we 60 of us had to actually come together to one place, would have required a lot of effort and aspect of 60 people's effort, right? One has to travel, one has to book, one has to manage the work, one has to manage the home. So there is freedom from geographical location in ODR and this kind of dispute resolution mechanism, because you don't have to travel anywhere. You just have to switch on to internet, proper strong internet connection, and then you're sorted. Now, organized digital data storage. Excuse me. Now, just as we talked about the ODR tools, we did talk about eBrief as well. So there is a platform through which there is an organized digital data storage, which is going to help us in actually accumulating all the data and make us understand that how it is being, how the data is actually being processed and how it is being saved and how can one easily access it. So these happens to be certain kind of advantages of ODR. And through these advantages, it is very easy and very acceptable for us to understand that ODR, online dispute resolution, does have its way ahead in the future, and this is going to be the new normal now. Right? In the past few years, we have seen how everything is being shifted online, how easy it has been for people to actually accumulate to this new online system. And ODR resolution mechanism, if adopted to full strength and full bloom, it is going to be a wonderful, like a blessing for all the people who have disputes and who are actually little afraid or skeptical to resolve the disputes because of the physical presence or the time taking or the money involved. Right? Having said that, there are certain challenges which happens to be in ODR as well. Because it cannot happen that everything happens to be very hunky-dory and very, very light and very swift for everybody to accept. So first of all, one of the major challenges which appear to be in ODR mechanism is that the lack of trust. Lack of trust between the parties, in the sense that they're not ready to understand or accept that, okay, I don't think that I want to adopt to this kind of mechanism, because it is related to the other point of challenge, that is a lack of awareness. They're not aware about ODR, or they're not aware about how ODR can actually resolve the dispute. And the aspect that is why there's a lack of trust and lack of awareness, which are interconnected. If a person is not aware, they'll not create a trust. right? So they go hand in hand. If a person is aware about the ODR mechanisms, maybe there is a slight chance, there's a major probability that they can develop a trust over it as well. Right now, the virtual world is another challenge. Why do we call it a challenge? Because in the aspect of the confusion, or let's just say how insecure this place could be, and how hazardous this place could be, and how misleading this place could be, in the sense that you do not know how your digital footprints are being taken up, how your presence has been encountered over the digital and virtual world. This can be a biggest challenge, and the lack of access of technology is another hazard, is another major reason for not accepting ODR as a dispute resolution mechanism. Because let's just accept that maybe people are starting using phones of their mobile network coverage in every village and every nook and corner, but they do not have the access to technology in this aspect. They're not aware. They do not have the access to technology. There are certain places still today where there is no proper network coverage, and there is no proper access to technology, and the fact that they're not aware about the communication devices through which this mechanism can run up. Right? So these basically are the challenges through which it is becoming difficult for us to actually entertain and accept any kind of awareness, or let's just say acceptability, to have ODR mechanism to be run as a fruitful and a full-fledged dispute resolution system. Another problem which is being faced is the lack of training to lawyers. See, we did talk about ODR as being one of the prime important and required form of dispute resolution mechanism, but it does involve training as well. If a person is not technologically friendly, or is not tech savvy completely, but is not aware about what kind of mechanisms or what kind of tools are being used to actually conduct this process smoothly, it is going to be a difficult and hazardous task for the people who are actually into this process. For example, if I am a mediator and I do not even know how to run this Zoom platform, how will I be able to facilitate and actually mediate the entire set of the meeting? I myself would be clueless, and other people involved would also be clueless at what is happening. So the lack of training of lawyers is also one of the prime reasons through which it becomes a very challenging job to accept ODR as a dispute resolution mechanism. I think I will end here. This is all I had to share, and if there are any questions pertinent to all the points which we have discussed, I'd love to take them.
Any questions from the participants? You can unmute yourself and ask your question, or you can even drop your question in the chat box.
Hi, this is Shobita. Ma'am, I wanted to ask if you could please elaborate upon the jurisdictional aspect of online dispute resolutions, specifically in light of choice of seat and other aspects. Thank you.
Definitely, Shobita. A very pertinent question you've asked. See, what happens in the case of international commercial arbitration, this seat theory and the choice of seat theory works under that only. So when we talk about international commercial arbitration, there are different set of laws which are involved in that, right? There is a lex arbitrae, there's lex pori. So now when we talk about ODR, all these kind of platforms, jurisdictional issues reduced to a certain aspect. And when we talk about jurisdiction issues, we're pertinently talking about the Indian aspect. In the Indian aspect, jurisdiction does not matter when it comes to ODR. If you're sitting in maybe Kolkata, I'm sitting in Delhi, I would not have to worry about that. Where do I need to file the claim? I would only be resolving through the dispute through an ODR mechanism, which is not following any kind of territorial demarcations and is not being actually, let's just say, fixed in the territorial jurisdiction only or pecuniary thing. I can actually declare, or let's just say, resolve the dispute while sitting in my place and you are sitting at your place, and will not be actually bound by the jurisdictional aspects. This makes it easy for us to actually deal with the dispute very easily. The seat theory which you're talking about, the choice of seat, happens to be in international commercial arbitration specifically, wherein you get to decide that how and when, let's just say, where the seat of arbitration would be and where the venue would be. So when we talk about the seat, we have to decide which law would be applicable, in which country are you going to follow. So this kind of jurisdiction does not happen in the case of domestic disputes when we talk about ODR in India. I hope I've answered your query.
Yes, thank you.
Most welcome. If this is,
Ma'am, I have one question.
yes, please go ahead.
Yes, if the part cause of action has been carried out in Mumbai and partially the agreement is carried
And
out
again,
in some other state.
Bichal, can you be a bit loud? There's a lot of
Yes, yes,
disturbance
yes.
at your end.
Now can you hear?
I can, but there's slight disturbance from your end.
Okay, okay, ma'am. Okay, 1 second, ma'am. 1 second.
Yeah, sure.
Yeah, can you hear me now?
Yes, perfectly.
Yes, yes, ma'am. So if the part cause of action is being carried out in Mumbai and part cause of action is there in Chandigarh. So how can we consider the further proceedings of arbitration? Like there is a final award which has been passed by the arbitrator and we need to pursue with further interim relief. So where we can, what is the jurisdiction for the court? Like how we can file that for interim reliefs?
See, interim relief under the section 9 and 17 of Arbitration Act, it happens. So if you're talking about arbitration, if arbitration is taking at a place, it is taking place online. But you want a relief at a certain place. For example, you talked about Chandigarh. Chandigarh happens to be the place where the dispute is arising. Obviously, the interim relief could be sought there, right?
Yeah, so basically there is a loan agreement and the corporate office of the bank is located at Mumbai.
Mhm.
And the signing and everything, there is for a person who has taken the loan resides at Chandigarh. So now he has defaulted in his loan and now there is a final award which is passed against him. There was arbitration proceeding. He didn't attend that arbitration proceeding. So there was an ex parte award against the person who has taken the loan. And now the arbitration proceeding has come to an end. There is a final award which is passed against that person. So can for section 9 now we are going forward. So now where we need to file in Mumbai or in Chandigarh?
See, you can file it at any place if the parties are agreeing. The point is that the ex parte decision can also be challenged, right? You can set aside the award, saying that you may be, if there are chances that you were not given a proper chance to present your case properly, you can set aside the arbitral award under section 34. It
No,
can
no.
either be,
Actually,
it can
we
be done at both the places. Yeah,
both the places. Okay, it can
yeah,
be done at both the places.
yes.
And whether the final now there is a final award passed. So can we go for section 9 or we need to go for execution of award
No, you
under
section
order
9 only
21?
happens. Section 9 only happens when the proceedings are going on. Since the award has already been passed, you can set it aside now under section 34.
So we can't go under section 9.
No,
You mean that?
no, you can't.
Because as per the section 9, it says that till the enforcement of the arbitral award,
And the
we
award is
have that
actually,
powers.
but this has happened in the case of ex parte. That is why. You obviously have this mechanism, but I'll tell you section 34 would be more effective here.
Okay, okay. So
Because
if
it is going to take a lot more process then if you involve court here.
okay, okay. So if it is not ex parte, then we can go for section 9.
See, I'll tell you, Bijal, you can still go for section 9. We're not denying to that, but it is going to be a
Okay.
time-taking process. Arbitration we adopt, that is why we only reason so that we can save time.
Correct, but to restrain that person to utilize his properties which have been
Definitely you
mortgaged
can
with
do that.
us.
See, I will tell you, I do not know the exact situation. Maybe we can connect and then I can guide you more properly.
Yeah, but I give her the background that we have given the loan to the person, so
Mhm.
we are the creditors, secured creditors,
Right.
and that's the reason now his mortgage properties are we are restraining him to utilize that properties or creating any third party right from on that properties.
Mhm.
So basically, for that purpose, we are going for Section 9 to get an immediate interim relief from
You
that
can do that.
final award.
You can do that.
We can do that. Okay.
Yes, you can do
Okay.
that. Definitely.
Okay, ma'am. Thank you so much.
Most welcome.
It was nice talking to you.
Same here. Thank you.
Thank you.
Any other question, anybody?
Any more questions from the participants?
think, Gauri, either I was too effective, or it people did not understand anything. I'll take up the first option.
No, no. I think there are no more questions, ma'am.
No problem.
Okay, thank you so much, ma'am. It was really a wonderful session and informative session too. So thank you for sparing your precious time for us and the participants. And for the participants, I would like to inform you that kindly stay connected, because another resource person will be joining by 5:30. So you all can remain in the Zoom this meeting.
Thank you so much, Gauri, for
Ma'am,
having me.
thank you, ma'am. Thank you.
Hello.
Yes,
Hello.
ma'am.
Ma'am, I actually have one more doubt. Can I just
Sure, ma'am. Sure, ma'am. You can do.
Sure.
Yes. Is the ma'am there?
Yes,
Over the
Bijal,
call?
I'm here.
Okay, ma'am. Okay. Hello.
Hello.
Hello,
Yes, Bijal.
am I audible?
Yes, you are.
Yeah, this is Bijal. I wanted to ask one doubt. Yeah,
Tell
if
me.
it is related to arbitration, that if arbitrator has closed any dispute for passing an award, okay, so within how many days he should pass an award?
Say that again. I'm sorry, could not catch you.
If an arbitrator has closed that matter for passing an award, then within how many days an arbitrator can pass an award?
Close that matter. What do you mean by that?
Close
Are-
as in, yes, decided that matter, that all the stages are done, but the award is not yet passed.
Mhm.
So within how many days an arbitrator can pass an award, like within a year or within 2 months, 6 months?
See, Bijal, there is no timeline for the particular time frame that after the decision is to be given. The time frame is only there for the passing of award, that within 12 months the decision has to be given in normal set of arbitration. Okay.
Okay.
There's no such timeline for the arbitrator ki agar aapke paas sare evidences and documents are there, now within this month, this much time that you've heard all the hearings, and after this you have to decide the award. There's no such timeline for that.
Okay. So if it gets delayed, then is it okay?
No, if it is getting delayed, that is from the date of initiation of arbitral proceedings, within 12 months, if the award is not declared, you can actually maybe challenge the appointment of the arbitrator and maybe set aside the award, arbitral award as well.
Initiation
can-
of what?
If the award is not delivered or is not granted within 12 months, then the fees of the arbitrator can be reduced. Okay?
Okay, from the initiation of the arbitration proceeding,
Yes.
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 Okay, but as per section 23, the arbitrator has to complete the pleadings within 6 months, and thereafter you have to pass an award within a year.
I'm saying 12 months ka time frame is there for the passing of award. You told me that Sara kaam ho chuka hai, and then how much time is to be given for him to pass the award.
Yeah.
There is no such
So
timeline for
in
that.
section 23, it is given that within a year, an arbitrator can pass an award. So in that case, in other cases also, he can pass an award in a year, like.
Right. Within this time frame of 12 months. And in the case of fast track proceedings, within a time frame of 6 months, he has to do it. 6 months also are given for the submission of statement and claim and defense. Okay. There is no such timeline given to arbitrator that after the statement of defense, yeah, or everything is been done or proceedings are done, within these months only the decision has to come out. The general
And what
timeline.
if the pleadings are not completed within 6 months?
Sorry.
What if the pleadings are not completed within 6 months?
Then the arbitrator's fees can be deducted.
Fees can be deducted.
Yeah.
Okay, but
For
what
the
if there is a delay on part of respondent or claimant?
then
One of them.
there are certain kind of whatever exemplary cost which is being there for the extra time taken, that will be levied on the particular party.
Okay, so do we have to file an application for any such thing for extending the
Bijal,
period of
I will
pleading?
definitely, let's just take this. I will share my number. Gauri will share my number with you. We can definitely take this up. This will require a detailed discussion.
Okay.
If that's not a problem, I'll be happy to help. No, that's not a problem for me.
Yeah, can you share me your number?
Definitely. Gauri, you will help us?
Sure, I'll help you out and I'll share the number, ma'am.
A number and email ID, both you can share to her.
Sure.
Thank you, ma'am.
Most welcome. Thank you so much, everybody.
Okay, thank you
Thank
so
you,
much,
Gauri.
ma'am. Thank you, ma'am. All the participants are requested to kindly wait till 5:30. We will be restarting the session at 5:30.
Okay, ma'am.
Ma'am, do we have some other session as well?
Yes, ma'am.
It will be starting at what time?
Ma'am, 5:30. We're just
Okay,
waiting for
ma'am.
the speaker to join. As soon as she
Okay.
joins, we'll start with the session.
Okay, ma'am. Very well. Thank you.
Okay, thank you, ma'am. Good evening, ma'am.
Good evening.
Hello, ma'am.
Hello, Gauri.
Ma'am, shall we start or should we wait for 5 more minutes?
No, we can start.
Okay, ma'am. I'll just give a brief intro and then we'll start. Okay.
Sure.
So once again, good evening, everyone, and welcome to the day 6 of the National Level Workshop, come 1 week faculty development program, organized by Guru Angad Dev Teaching Learning Center, a scheme under Pandit Madan Mohan Malviya National Mission on Teachers and Training, Ministry of Education, Government of India, powered by Droid Pinal Group, a unit of Arjun Das Gulati Memorial Society, So for day 6 and the second session, we have with us another resource person, Mrs. Shushmita Mukherjee, Advocate, Allahabad High Court. And she will also be sharing her views on the alternate dispute resolutions. So good evening and welcome, ma'am.
Good evening.
And ma'am, you
Thank
can
you.
proceed with the session now.
Thank you for having me. Now, today I'm going to take a session on alternative dispute resolution. And now, as the name suggests, stands for ADR. It is an attempt to devise a machinery. Basically, we have to think about the time where there was no such machinery, where we could think about a dispute resolution outside the court proceeding. So basically, ADR talks about all those mechanism, all those opportunities where a matter, a dispute between two parties can be taken up and discussed and solved outside the court proceedings, and which also becomes binding. Now, ADR is supposed to be a mechanism which is capable of providing an alternative to conventional method. Now we know this conventional method we are talking about. We know that there are two types of judicial system actually. So one such judicial system is that one is adversarial in nature and one is inquisitorial in nature. Our country, if we don't talk about the juvenile law, we don't talk about, because juvenile focuses on inquisitorial law. The method which is followed is inquisitorial. But apart from that, the method which is followed everywhere in the court, it is adversarial system. Now, adversarial, what is adversarial? It is like that when two parties, they face a dispute and they are unable to resolve that dispute between themselves. So they only have, because we know this famous saying that where there is a right, there is a remedy. And because if we have a right, then there is a situation that right can be violated. And when that right is violated, then the recourse would be to take it in front of a court. So the adversarial legal system talks about, deals with the fact that when there is a dispute, the parties to a dispute, there can be one party who has a right and there is another party who has infringed that right. So both the parties, they appear before the court, and now they cannot directly appear, because adversarial legal system, it talks about a procedure where you have to approach the lawyers, the law knowing people who are also the advocates, the advocates who they are representing by way of a wakalatnama, they are representing the parties. Now the advocates, they prepare their respective matters and then they approach the court after filing the case. The court, being the you can say the impartial party, hears the matter, understands the law, and then passes a judgment. So this is what an adversarial legal system is. Now what happens is, ADR, when we bring ADR about it, now this process of approaching a lawyer and filing a matter, then there is a huge caseload in our country. And because of this, it is first very expensive. Second, it is time consuming. And third, that the harassment a person goes through, because of all these factors, because it is time consuming, because it is expensive, the person goes through the mental trauma and the harassment of going to the court every day. The matters are not getting taken up, huge pendency. And this huge pendency, this is nobody's fault. Our system, our country is a heavily populated country. And as if you have studied about law and society, we can say that wherever there is wherever there are people living, they tend to enter into disputes. This is you can say how a person behave, this is a human conduct. I may do something, the other person might not like that, and that might start a dispute. So wherever there are people living, there tends to be, rise in the number of disputes. As a result, what happens? The pendency, it increases. So now if we talk about the two parties who are in disagreement, in order to save time, in order to save money, they can go for an alternative dispute mechanism. Now this need, because if I give you the data, a very surprising data is that if you see about the present trend, not the present trend would be that more than 3.5 crore cases are pending in the district court alone. I'm not talking about high courts here, I'm not talking about supreme courts here. So you can see with this amount of pendency, it becomes very difficult, because let's face it, the advocates and the judges, they're all humans. It becomes very difficult to dispose of a matter, hear the matter, see the intricacies, and then dispose of the matter. So as a result, the pendency increases. And this, because of the pendency, it becomes where the cases, they tend to go on, linger on for years. Now, in 1993, actually, in light of all these concerns, the then Prime Minister and the Chief Justice of India, they convened a conference in New Delhi, and they adopted a resolution. I may read the resolution. It stated that the heads of the government and the highest judges agreed that the courts couldn't handle everything, and that some conflicts were better suited to being settled through arbitration, mediation, or negotiation. They stressed the value of parties to a disagreement using alternative dispute resolution, which can provide procedural flexibility, save time, money, and reduce the emotional and mental strain of going to the trial. Now, if we see this, it's actually, talking about that because of the rise in the cases, it becomes impossible to hear all the matters for the court to hear all the matters. Now, some of the cases are, the nature of some of the cases are also like that it becomes difficult to, for example, matrimonial issues. Now, what conspired in the four corners of the house, a judge sitting, an impartial judge sitting at that pedestal, won't be able to deduce that which party is saying the right thing, which party is in the wrong. So better way of solving these disputes always are the alternative dispute resolutions we are talking about. Now there are kinds of ADRs, that is your arbitration, conciliation, mediation, lok adalat. These are judicial proceedings by way of lok adalat. Now, if we talk about the origin of ADR, now ADR, if we see that ADR today is being increasingly acknowledged. Why acknowledged? Because of the nature of cases. Now we see that our country is now becoming, very advanced as far as your technology is concerned, advanced as far as your business is concerned. So when in all these fields, disputes do arise. Now, the way to solve these disputes in the commercial sector, the efficacious way would be to refer these matters to ADR. Now, since we are talking about the origin of ADR, we will see that what led to the formation of need to form a mechanism for ADR was the tiresome process of litigation, the cost, and the inadequacy of the court system. Now, it is quite, it's not, it's not very difficult to believe that these process, because of the huge pendency, it becomes difficult. The court systems, with its present, strength of judges, it becomes very difficult and inadequate for solving all the matters. So that actually became the reason for the rise in the ADR mechanism. Now, let's talk about the legislative recognition of ADR, because let's face it that for a law to be recognized, you cannot just have it or know it. It has to have a statutory, a statutory authority from where it is taking its shape, from where it is taking the power. Because everyone who acts in such a way needs to have a power from somewhere, and that somewhere should be a statutory power which is given to it. Now, if we talk about the legislative recognition of ADR, this was under there are many actually, because we are talking about mediation here, we are talking about arbitration here, we are talking about conciliation here, and judicial proceeding like Lok Adalat. So if we talk about Lok Adalat, then the legislative recognition would be the Legal Services Authorities Act 1987. Now, the Legal Services Authorities Act 1987, it brought about the establishment of Lok Adalat for settlement of disputes, which could be, done cheaply and expeditiously. Because the main aim, why from the normal court proceedings, why are we moving towards ADR? Because we want to have some mechanism which is cheap as well as which is expeditious. So this Legal Services Authorities Act, it was formed to introduce Lok Adalats in the system. Eventually, I'll be telling about Lok Adalat. I'll be dealing with, all the kinds of ADRs, starting from arbitration, moving on to conciliation, mediation, and then Lok Adalat. And now if we talk about the other provision, that provision would be your Section 89 of Civil Procedure Code, which came by the Amendment Act of 1999. Now, before 1999, there was no such provision, but then, with the advent of all the talks about ADR and everything, this provision was introduced. And I'm repeating again, this provision was introduced by the Civil Procedure Code Amendment Act 1999. It carries out Section 89, and it was designated to enable the courts to bring about a settlement outside the court premises. Okay, now then if we go through Section 89, Section 89 also talks about all these measures. It talks about arbitration, as I'm not repeating again, all the kinds of arbitration it talks about. So now another important thing which I want to tell you is that it has now made ADR obligatory. So now, it's not that somebody wants to go for out of court settlement, or somebody doesn't want to go for out of court settlement, but Section 89 has made it obligatory, that now the court will have to refer the disputes to the outside, whatever the outside court settlements are, preferable in that condition, be it mediation, be it arbitration. If there is an arbitration proceeding, if there is if there is an arbitration clause in the agreement, then it is mandatory that you have to refer the matter to arbitration before approaching the court. Once you've referred the matter to arbitration, you've gone through the entire procedure, the award has been given or not, has not been, but you have to first, go through and see that whether the arbitration proceeding is working out for you. Only then, if you're not satisfied with the proceeding, only then you can approach the courts directly for whatever the dispute that is there. See, many people think that Section 89 is taking away the power of a person to approach the court. Like, I'm an advocate, I also get so many clients asking that, like, the first duty of an advocate is to try for a settlement. It's not filing a case. So the first question you have to ask is whether there is any room for settlement. If you try, or you use your good offices to see if the matter can be settled. So now, once you've done that, many clients come and ask that they have that fear that if we go through this process or procedure, we might end up accepting something which we are not supposed to, or we might end up being forced upon you. But that is not the case. If you're not happy with the the proceedings of the arbitration or the mediation or the conciliation or any other, there is always the scope of challenging the same in a higher court. So by if the ADR is there, it is not taking away your right. It is not taking away your right to file a case, because the maxim of equity, that where there is a right, there is a remedy. It cannot be taken away by a person. So where there is a wrong which has happened, and there is a right, and the wrong there has been an infringement in that right, then you always have a remedy. If you go through section 89, it doesn't mean that you're finishing off that remedy. It's still there, but you're just giving it an extra push to see if the matter can be settled outside court or not. So now, as I was saying, that it has now become obligatory that the court will refer the dispute after the issues are framed. Now this part is very important, that once the matter is filed, it is not that you refer the matter directly to the whatever the tribunal is, but first you have to frame the issues, that this is the matter and these are the issues which are involved in the matter. After framing of the issues, the matter has to be, and that should be in concurrence with the parties. Both the parties to the dispute, they have to give their consensus. It's not that you are being forced to do that, but they have to give their consensus, and after taking the consensus, after framing of the issues, the matter can be directed or referred to arbitration, conciliation, judicial settlement like lok adalat, or mediation. Now there is, as I was saying, there is always a situation that where the parties fail to get their disputes settled through alternative dispute resolution methods, the suit would actually come back to the place where it was left. You will not have to file the matter again. It will actually come back to the place where it was referred. For example, if the pleadings were complete and then the matter was referred to for some ADR proceeding, then when if the ADR proceeding gets cancelled, like the arbitral proceeding or the mediation proceeding gets cancelled or rejected, or it fails basically, so it will go back to the court at the point exactly where it had left. Now if we are talking about ADR, we should always be mentioning and taking a note of the Justice Malimat Committee, because Justice Malimat Committee was known one. It had reformed the criminal justice system, so that is one important factor. The other factor is that it also, it agreed with the Law Commission. I just read you the report, where the need arose that yes, now the courts are facing, a lot of pendency, and now it is, a mechanism has to be evolved so that it can be referred there. So Justice Malimat Committee agreed to the Law Commission recommending that a conciliation courts should be established all over the country with powers, authority, and jurisdiction, so to initiate conciliation proceedings. So also, if you're referring a matter to some tribunal, mediation, conciliation, or arbitration, that tribunal should have the power to take steps. The power should be there, the authority should be there, and the jurisdiction also should be there. Now, jurisdiction is something you cannot do away with. For example, if a dispute has arisen in Allahabad, suppose, or in Delhi, then you cannot approach, Bombay mediators or conciliators to solve the matter. The jurisdiction, unless otherwise agreed, if all the parties are agreed that they are satisfied with then later on they will not be, raising a question on the jurisdiction. So jurisdiction matters. Many a times what happens, an arbitrator who's appointed, that arbitrator may be sitting in Delhi and the matter is of, suppose, Bangalore. the parties, if they have given their consensus, later on they cannot say that when the award comes, they cannot challenge it on the basis of the fact that, the jurisdiction is not there, because they had given consensus as to the seat of the arbitral tribunal. So if the matter is of Bangalore and they have given a consensus as to the seat of the tribunal to be Delhi, later on when the award comes against us, award, you understand, award is the decision of the court. If we are talking about arbitration proceeding, the decision of the arbitral tribunal would be called an award. So now, if a award comes and that award is against you, so you cannot take jurisdiction as a you can say as a way to vitiate the matter, because you yourself have given consensus over it. So yes, so Malimat committee we were dealing with. Malimat committee recommended that it is obligatory for the courts to refer the dispute after issues are framed for settlement, either by way of arbitration, conciliation, or all the other mechanisms. So yes, anybody has a question? Okay, so what I'm saying is that this Malimat committee is actually the one which made it obligatory, and in that light, Section 89 came. Section 89 came where it is making it obligatory that you have to the courts have to, after framing of the issues, the courts have to refer the matter to whatever the ADR mechanism is. Okay, now this is what your ADR is. Now let's bifurcate, like deal with all the types of ADR, the kinds of ADR, as you say. So now the first one is arbitration. Now arbitration and conciliation, okay, it goes side by side, though a totally different, totally opposite thing, but it is dealt together. Now arbitration and conciliation is supposed to be the most preferred system of resolution of a dispute in India. So the reason why I'm telling you is that arbitration is a step less than the court. In arbitration, you can either hire the retired high court judges or the Supreme Court judges, or someone who has the know-how of the case. If suppose someone is specialized in something, so that person is capable of becoming an arbitrator. So arbitration, as I'm saying, is just a step lesser than the court, because in arbitration you will see that the procedures are more or less similar to the court procedures. Now, if we talk about the origin of arbitration, we see that it's not in 1996 or 1940 this arbitration proceeding came. Am I audible?
Yes, ma'am. Yes, ma'am, you're audible.
Something is the issue with, I think, the internet. I'm audible? Okay,
Yes,
okay. Yes, so continuing with the arbitration proceeding. if we talk about the pre-British period, talked about, you can see the panchayat which happened, which was more or less like arbitrators also. And with the advent of the British period, what happened was that steps were, because Britishers, let's face it, that Britishers were more organized. Britishers gave us the concept of codification. Codification, if you understand, is that laws cannot be, it was not that rule of law, like the king is above all, and the king is the maker of the law, the legislator, and if the king feels that he will do it at this way, that becomes the law. If the king feels that he will do it that way, that becomes the law. It's not like that. The Britishers gave us the concept of codification, which stated that laws needs to be codified, and the statutory importance of a law. So basically, when pre-British period, there was no law. It existed in the form of panchayat. After the British period, what happened? That certain laws were formed. Now, the first law which is there is the Indian Arbitration Act 1899. Now, Indian Arbitration Act 1899 was actually a copy of the English Arbitration Act 1889. Okay, now it was considered to be the first direct law on the subject of arbitration, but its application was only limited to the presidency towns. Like we have the Calcutta, Madras, and Bombay. The presidency towns were there. So its application was only limited to the presidency towns, but this was considered, the 1899 one is considered to be the first direct law of arbitration. Now, after that, the Indian Arbitration Act 1940, which worked for a while. This act was the 1940 Act repealed your 1899 Act. So for the first act was Indian Arbitration Act 1899. This was a copy of the English Arbitration Act. And after that, when the 1940 Act came, it repealed the Indian Arbitration Act 1899. Now, after that, the actual important act, which we are still, which is still going on, there has been many amendments, but this act is considered to be the present existing one. That is the Arbitration and Conciliation Act of 1996. Now, this act was, formed to consolidate and amend the laws relating to arbitration. So the reason why this act was there, because there was a lot of haphazard things were there. The 1940 Act also created a lot of problems, lot of issues, which were later on, corrected by way of the 1996 Act. So to consolidate and amend the law relating to arbitration, international commercial arbitration was also brought in, and enforcement of foreign arbitral award. So Arbitration and Conciliation Act 1996 was, to consolidate all these acts, to bring them together under one act. So it is, and also it is important to know that it is based on the UN Citral model law and rules. Now, though you can say the UN Citral model laws and rules are intended for the international arbitration and conciliation, but they also form as a you can say they are taken as a model law for arbitration. So basically, our Arbitration and Conciliation Act of 1996 is a copy of and is based on the model of UN Citral law. And that is why this becomes a very important part, because many things which were not there in the 1940 Act, it was brought through this. Now you can see that this Arbitration Act is considered to be a very exhaustive act. Now, why is it an exhaustive act? Because exhaustive actually means that an act which deals with every aspect of that particular subject matter. Now we are talking about arbitration. It is talking about international commercial arbitration also. It is talking about foreign arbitral award also. So as you see, it is it is consolidating in nature. So it's bringing all the international part also in this under this under the same act. So it is exhaustive in nature. If there is an arbitration dispute, arbitral dispute, there is a clause in the agreement which talks about your arbitration, then this act is the one which has to be seen to. Okay, now by virtue of the provision of section 5 of the act, just a second. Section 5 of the act talks about extent of judicial intervention. Now, it is stated here that notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. So I'm reading it again if you're not, read it too quickly. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Now, this act makes it very clear that even a judicial authority, that no judicial authority, which would also include courts, can intervene except otherwise provided. So if the act anywhere is making any provision that here the high courts or the supreme courts can intervene, only there the judicial courts can intervene. Apart from that, no judicial court can intervene in any place. So if you want to, after starting an arbitration proceeding, after the reference, once the reference is made to the arbitrator, once that is done, you cannot approach the court for anything except otherwise provided in the arbitration proceeding. So if you are approaching the court for some part, the specific provisions have to be there in the Arbitration Act. This is the 1996 Act. So therefore you can say that just a second. Yes, unless and until the remedy is provided in the act, it would be impossible for any courts to intervene in the matter. So you can say that this act is very well, it is a self-contained and a very exhaustive act which contains everything, and you will not have to go through other acts to take help. Now, another thing you have to know about arbitration is that the act it doesn't have a retrospective effect. Now, if we are talking about retrospective, one thing has to be clear, that a law is deemed to be prospective unless and until somewhere a mention is made that this act is retrospective. So if there is no section or no provision written in the act that the act is retrospective, it will be deemed as prospective. So if we see it like that, this act is not retrospective in nature, which actually means that if suppose the dispute is of the time before 1996, then this act will not be applying on 1996 a dispute which is existing before 1996. So if a dispute dates back to the time that is before 1996, then the 1940 Act, if you remember the 1940 Act, the earlier act, which was repealed by the 1996, that act will be applying on the same and not this one. So that is why when we are talking about, and also as far as your amendments are concerned, we have to see that when that dispute was raised, and that time becomes important. So once you're raising the dispute, you have to see that whether you are, before or after that particular date. Okay, now there are certain principles which govern the arbitration. The first one is the quickness in achieving resolution of disputes by a domestic tribunal without any unnecessary expenditure. Now you have to understand one thing, that ADR focuses on the fact that because courts were becoming expensive, because you have to hire a professional, because see, if someone is sick, then we'll have to of course go to a professional, a doctor, to treat. So in similar way, if there is a dispute which is existing, which is of legal nature, the person will have to approach a professional, and a professional will obviously charge their uh, due fee, whatever is stated. But in this ADR, the participation of the advocates are less. Like in arbitration, the participation of advocates are there, but if with the advocates, the clients are also participating, so the transparency is more. They are also are given an opportunity to express themselves, to see and make the arbitrator understand what the dispute is. So they are also participating. Also there is a provision that if they don't want to appear through an advocate, they can even do so. So arbitration nowhere makes it mandatory that you have to appear through an advocate only. You can directly appear in an arbitration proceeding without an advocate. So that is how it becomes a little cheap than your normal litigation. Okay. Now the second point is that the parties have been given a choice with which they wish to refer the matter to arbitral tribunal. Now it is totally depending on the parties whether they want to move the arbitration proceeding or not. If they are not giving the consensus, they don't want to take this choice, it is totally dependent on them. It is totally their choice whether they want to go to the court or they want to go for arbitration or any other ADR proceeding. But they will have to make an express statement saying that they are not wanting to refer the matter. And if one party is making an objection, then they will have to fight it out in the court. Then third would be the will of the parties shall prevail without intervention of the courts, except section 8 and section 9. So when in every ADR mechanism, the will of the party becomes very important, that whether the parties are willing or not. That is the very essence of ADR, that whether the parties are willing to proceed with ADR or not, because that will actually doesn't work in adversarial legal litigation, where there is a dispute and you have no other recourse. You have to appear before the court and state your case. The impartial judge will hear the parties and give their decision. But in ADR, the choice and the will is of the parties whether they want to do it. And except section 8 and section 9. Section 8 talks about power to refer parties to arbitration where there is an arbitration agreement. So now there are two types of arbitration which happens. One is a statutory arbitration and the second one is a consensual arbitration. Now statutory arbitration is something where like two parties, they enter into a dispute, and those two parties, they are sorry, not a dispute, those two parties, they enter into an agreement to do a work. And whatever the time frame, whatever the money, whatever the thing is, that they enter into an agreement. Now those two parties, a dispute arises between them stating that this matter was not done within time, or they are charging a lot, or whatever the dispute is. I'm not going into the subject matter of the dispute. Now once the dispute is there, the arbitration clause will be referred in the in the agreement, the contractual agreement which was there between the parties, binding the parties. There is an arbitration agreement. So if there is an arbitration agreement in it, it will be called a statutory arbitration. Statutory arbitration means that you don't have any recourse. If there is a dispute, you have to refer the matter to the arbitration. The other one which we are talking about, that is consensual arbitration. Consensual arbitration is when there you are suppose you're working, two parties are working together, and an agreement, contractual agreement exists between them or doesn't exist. So once that is there, the parties, if there is a dispute, which has happened between the parties, now the parties can decide that yes, there is a dispute, we don't want to go for the court proceedings, because the court proceedings are will take a lot of time, will be very expensive, because they will have to hire advocates and everything. So they choose for arbitration. And so this arbitration, with the consensus of both the parties, this arbitration becomes, consensual in nature. And in this type of arbitration, they can either go for it, or they cannot go for it. So the first part which we were talking about, the statutory arbitration, that becomes mandatory, and that is governed by your section 8 of the Arbitration and Conciliation Act 1996. Now this talks about that where the arbitration agreement specifically mentions a clause about arbitration, that if there is a dispute, the parties will refer the dispute to the arbitration, then section 8 will be invoked. Section 8 states that the parties will have power to refer the matter to arbitration agreement. And section 9 is interim measures by court, that during the arbitration proceeding something happens, they can go to the court. If suppose there is a termination, or there is anything, so they will be able to approach the court. So except for section 8 and section 9, except for section 8 and section 9, yes, am I audible?
Yes, ma'am, you are audible.
Okay, so except for section 8 and section 9, the entire act says that there is no, that the judicial courts will not be intervening in this. So the judicial courts will be intervening in section 8 and section 9, but no other place. Okay, now the fourth part states that parties shall be treated equally, and procedural laws will have no applicability before arbitral tribunal. Now, whatever the seat of the arbitral tribunal is, or whoever the arbitral tribunal is, the procedures and the laws will be equally applicable on both the parties. It will not be pick and choose policy that it's the arbitral tribunal's whim, or the arbitrator's whim, that I am supposed to place this law on this person but not on this person, or I think that this person is behaving properly, so it doesn't happen like that. Arbitrator is still an impartial person, a neutral person, who will go through the dispute, and every law will be equally applicable on both the parties. Now, the procedural law will not be working on the applicable on the parties. Now what happens is, when the arbitration proceeding takes place on the initial dates, when the matter has been referred to the arbitrator, and the arbitrator gives a consent that yes, I'm willing to act like an arbitrator and in the aforesaid matter, also gives a declaration that the arbitrator in no way is related to any of the parties. So that declaration becomes very important on the part of the arbitrator. He has to state that by any means the arbitrator is not related to any of the parties, and has no interest in the matter which has been brought in front of them. So first, a consent has to be given by the arbitrator that yes, you've chosen me as an arbitrator, I will be solving the dispute. And second, a declaration on the part of the arbitrator has to be given. Only then the matter commences. So after the matter commences, the first sitting always takes place. On the first sitting, the arbitrator will be deciding that, see, CPC and your procedural law, CPC, as well as your evidence law, these will not be applicable on the arbitrator or the arbitral tribunal. But if the arbitrator is supposed to frame rules and laws, that this is my arbitral tribunal and these are my rules and regulations, because this is very different from court proceedings. Like in a court proceeding, you actually have the place to, there is a high court or a lower court or a district court where the court proceedings takes place. Now for an arbitration proceeding to take place, you don't have a place. The seat of the arbitrator have to be decided. It can be anyone. The seat can be a lounge in a restaurant. It can be a conference room. It can be a person's place. It can be anywhere. So for that, the comfort level is also there, where you are sitting at the comfort of your house, and that becomes the arbitral seat. So that comfort is given, that relief is given. So once that you are sitting for the discussion, you first have to decide, the arbitrator first has to decide what procedure to follow. So suppose if the arbitrator says that, see, though CPC is not binding on me, but even then the procedures as far as the evidence, because in arbitration it actually goes on like a suit, that where the evidence has to be taken, the issues have to be framed, and then they have to be examination, cross-exam, all these things happen. So that is why it is important that in the first sitting the arbitrator makes it clear that what is the rule procedure or the rules which are supposed to be applicable in the arbitration proceeding. Now, if a challenge to the jurisdiction of the arbitral tribunal does not succeed, the arbitral proceeding shall continue till the arbitral award is made. So also, like if somebody is not challenging the place of the arbitral proceeding, as I was earlier saying, that if the dispute is of Bangalore and the arbitral seat is Delhi and nobody is challenging it in between, or everybody has accepted the seat as Delhi, then later on it cannot be changed. Till the award is made, you have to follow that. In between, you cannot change it. That, see, we've sat here for 5 weeks, now we are not supposed to, we have to shift it to Bangalore. You cannot do that. Once you've accepted the place, accepted the seat of the arbitral tribunal, you have to continue that without objection till the final award is made. Then if parties cannot choose the venue, the arbitral tribunal will choose the venue. So the arbitral tribunal will be choosing the venue if the parties are not providing the same. Otherwise, the first choices of the parties, whichever party is wants to choose. Now, if there is a it might be a situation that one party is saying another venue and the other party is saying another venue, then it can be this or that. On one date this venue can happen, on the other date that venue can happen. So it happens like that. So you see that this is a very informal type of, though it happens like court, everything happens like court. Matter is argued, evidences are laid, cross examinations happen, examination happen, witnesses come, they are examined, all these things happen as like a court proceeding, but a little less formal. And so you can say that the fear people might have of the court, that is not applicable here. So also if we I've already discussed about the statutory and the consensual, because under statutory it is the exclusive jurisdiction. Wherever the arbitration agreement talks about contractual agreement talks about arbitration, it is exclusive jurisdiction, and in case of dispute you have to go for arbitration, and there is no other way out. In case of consensual, it is open to a person that whether you want to go for arbitration or you don't want to go for arbitration. Now, as I said, I've already dealt with that whenever the dispute appears, you have to refer the matter to the arbitrator. So the reference is made. So it might be that one party once there is a dispute, the one party moves an application before the second party. The second party will go through the application, see that there is a request for referring the matter to the arbitrator. The second party will choose an arbitrator and take the consensus, and then take the consensus of the arbitrator. The arbitrator will give consent, will give a declaration, and then the matter will proceed. So this is the entire the procedure which is followed. And then it happens like a court. As the matter happens in a suit, the procedure takes place in a suit, exactly in the same way it moves forward. So you can say that the main sense of arbitration is that it must be expeditious. So I know there is always a lingering doubt that the procedure is too technical, too almost like a court. It's just that the venue is not court. Venue is not court, and it's a less informal. So that is why in the very beginning I said this is just a step lesser than the court. That if you don't want the entire the strictness of a court and all those things, then you can choose for arbitration. And also it is like a court, but it is taking the burden away from the court also. So that is why it becomes an efficacious remedy for dispute resolution. Now then your certain amendments also came in the Arbitration and Conciliation Amendment Act 2015. Now this has earlier there was no time limit fixed. So you see that what used to happen was, first one for which ADRs were the concept of ADR came was, one was money, so it has to be cheap. Second was time, that when you refer a matter to the court, it takes years to finish up. So earlier in arbitration also this happened, that it used to take years to finish off with a matter. But then the Arbitration and Conciliation Amendment Act 2015 came, where it has fixed the time limit of 1 year for the arbitral tribunal to make an award. So once a matter has been referred, then the entire time which is given is just 1 year, and within that 1 year the entire thing has to be completed. For example, completed means that the award has to come. Now as far as the date is concerned, now the date is to be computed from the date the tribunal enters reference. Reference means that when you refer the matter, the tribunal gives the consent, and after the consent letter and the declaration, when that comes, that is where the tribunal is entering reference. So the date is to be computed from the date the tribunal enters reference, and from that date 1 year time is given. And in that 1 year time, the arbitrator have to hear both the parties, go through the entire procedure of leading evidence and all these things, and then give an award. So that solves the time issue. Now there is this very important 2019 Amendment Act. It relaxes the provision, because you see that many a times the procedure should not be that hurried up also, where you feel that because you had to follow the time schedule, that you just hurried with the entire proceeding, and in the end the result is that since the arbitrator had to follow that time constraint and gave a judgment which was not worth it. So that is why, seeing all these impracticalities, the Amendment Act 2019 came. 2019 relaxed this provision of 12 months constraint, and that 12-month limit, it stated that the 12-month limit shall begin after the completion of the pleading. Now, completion of the pleading means that the pleadings between the parties have been exchanged. Like, the claim is filed, the counterclaim comes, the defense comes, and then, your applications of this, that, everything comes. And when that finishes off, that is when your 12-month will start. So that is why, because many a times we have seen that, I mean, my experience with arbitration, I do a lot of arbitration matters, I've always seen that because the parties are giving a lot of applications and it is important to dispose of the applications, and as a result a lot of hearing happens only on the applications, then what happens that the time constraint of 1 year just passes like that. So that is why it is mandatory that that time or the 12-month period, it will start after the pleadings are complete. Okay, now another thing I missed out on the 2015 amendment is that the 2015 amendment provided for extension of this period either by the parties or by court intervention. So the party, if the parties want, they can suppose the arbitral tribunal is just going on with the matter and it's going fine, and but it takes time and the 12-month period expires. So the 2015 amendment stated that the parties can move an application before the High Court and request for a time extension. Without time extension, the mandate of the arbitrator finishes off and the arbitrator cannot move ahead. So once that mandate finishes off, a time extension has to be, an application for time extension has to be filed before the High Court. High Court will extend, only then the arbitrator will be able to move ahead with it. Now, what is important, the decision of the arbitrator, it comes in the form of the 21C of the act talks about what an award is, the final decision that is given by the arbitrator, that is called an award. Now award can be a final award also or a partial award also. Like when the issues are framed, there can be 10 issues, suppose 10 issues are framed and the arbitrator only decides 6 of the issues, remaining 4 issues are still left. So if the arbitrator gives a decision on the 6 issues, then it will not be considered as a final award, it will only be a partial award. So award can be of two types, final award or partial award. Then you should be knowing between the distinction, should be knowing about the distinction of between order and an award is. Order is, it can be just any order. Like for example, if I am not ready for appearing at a particular date, I might request for an adjournment and the court might grant me an adjournment. So when the court is granting an adjournment, that adjournment order doesn't, it is not an award, it is just an order. So there is a distinction between order and award. Award will only either create somebody's right or will diminish or diffuse somebody's right. So any decision given by the arbitral tribunal, if it is either creating somebody's right or diffusing somebody's right, so one, if somebody's right is being created, the other person's right is being diffused. So if an award is doing that, then only that decision can be called as an award and not an order. So this is the distinction between an order and an award. Now, regarding also one thing which is important is that the award should be in writing, it should not be an oral award, and it should be signed. If it is not signed, it cannot be enforced, then you have to put it before the court for the enforcement. Now, as far as the number of arbitrators is concerned, it is a laid down rule that if the a contractual agreement is not talking about the number of arbitrators, it is considered to be a sole arbitrator. So if the contractual agreement is saying that there has to be 2 arbitrators which have to be appointed or 3 arbitrators which have to be appointed, then the number is clear. But if it is just talking about arbitrator, then the rule laid down law is that it will be treated as a sole arbitrator and there will be no dispute regarding the number of arbitrators to be appointed. Okay, now this is all about arbitration. But then you'll notice that arbitration is arbitration, as I said, was a step lesser than the court and is still a very formal procedure. Now comes your conciliation. Now Conciliation mainly talks about settling of dispute without litigation. So you can see a hint of litigation in arbitration, but that hint you will not get in conciliation, because it is a process in which an independent person, they are appointed. Independent person means a person who's neutral, he is appointed, and with mutual consent by agreement, to bring about a settlement of dispute between the parties in consensus, and by using this is important, persuasive technique. So you see that when persuasion comes, then deciding a party, adjudication, it just takes a side step. So arbitration is actually adjudication. Adjudication, I'm trying to break the word adjudication. It means that when a dispute is handed over to the neutral party has to hear both the parties, go through the evidences which are placed on record, and then give a decision. That is adjudication. But persuasion is different. A court never persuades a party. Persuasion means that you try to make one party or the other party, you try to make them understand, that that how you can resolve the dispute. So basically the idea, the criteria behind conciliation, very different from arbitration, is that you finish off a dispute by using persuasive. For example, if I'm a conciliator, somebody comes with a dispute, I'll try to resolve the dispute rather than give a decision. I'll try to make them understand that you leave one thing, the other party leaves another thing, take both of you take a step back, and then you try to resolve it. So this is how conciliation happens. Now, very important factor which is there in a conciliation is that these are essential ingredients which are part of the conciliation, is that you have to have confidence, you have to have trust and faith. Arbitration was different, it was adjudication. Here you have to have that faith in the conciliator, because for example, if I'm the conciliator and two parties are sitting in front of me and they don't have faith, one of them suppose don't have faith in me, they will not understand or doubt my allegiance, then I won't be able to decide the matter. One of them will keep doubting me. So both the parties have to have that confidence, trust and faith in the conciliator, that whatever the conciliator is trying to make them understand, it's for their own good. And everyone has to take a step forward, understand what the problem is, and then solve the dispute. So also, if we talk about arbitration, you can say that gone are the days when arbitration proceedings were considered to be cheap and efficacious. You see, I just explained what arbitration is. It is okay, it is like court proceeding. It's only that the venue and all these things is a less formal than the court, but the procedures are almost the same. It happens like a suit, like a civil suit. So and also it was quite cheap, and it was quite efficacious once. But with the changing passage of time, so many amendments had to happen, so many case laws happened. If you now find out about case laws of Supreme Court on arbitration, you will see that so many, like the Vidya Drolia law, and so many laws have come where it has actually changed the way how you can say how you used to take arbitration. So it can nowhere be considered, because you have to meet the arbitrator's expenses also, you have to meet your advocate's expenses also, you have to also bear, if it is not happening in somebody's house, it might happen in a restaurant lounge or a conference room, so you will have to bear the expenses of the venue also. Plus whatever the expenses of steno, expenses of clerks, all these things have to be borne. So you cannot consider arbitration as a very cheap procedure. It has become very expensive. The only fact is it is time bound. You will be expecting to get a relief in a year. But now also we are seeing, as since I'm dealing arbitration cases, I'm seeing when one party is not satisfied with the arbitration tribunal and gets a whiff that that the decision might not come in their favor, they just move any application before the High Court or the Supreme Court with any pretext, and and go for changing the arbitrator. So that is why it has not remained what it was supposed to. So but if it's a statutory arbitration, then you have no other recourse than to file for an arbitration application. Okay, now also it has become very technical also if you see arbitration. So conciliation is considered to be quick, to be considered to be economic, and social. So you don't have to think about venues, you don't have to think of places. It's informal. You can just sit in an office or your drawing room or any restaurant. You sit with both the parties, try to. So basically what is happening, negotiations, and then making the person understand. So it is quick, it is economic, and quick, economic, and then your it is social also. So social in a way that when you make one party understand and the other party understand, that they are, at the end of the day, they are happy. So once you are trying to bring them together also, it's like a bond which you're creating. So that ways it is economical, it is quicker than your arbitration proceeding. Now also, if you see, compare, I think arbitration proceeding has become so technical that now it can be like civil suit is better than arbitration proceeding. Why? Because civil suit, there are just 3 steps involved. One is filing of pleadings, second is conduct, and the third is judgment. So you file the pleading, then you conduct the proceeding, and then the judgment is given. In an arbitration proceeding, on the other hand, you have to appoint the arbitrator, that is one step. The pleadings, that is the second step. The proceeding, that is the third step. The award, that is the fourth step. Filing of the award in the court is the fifth step. And then if you're not happy, one of the party will not be happy because it's an adjudication, so they will challenge the award, then that is the sixth step. So 6 steps are involved in arbitration, but under a civil suit only 3 steps. So you can say it's not at all, it's becoming, with the passage of the time and as case laws and all these things are coming, it is becoming too technical. So conciliation is a very effective method if the parties are willing. Trust me, it actually depends on the parties. So because another thing which is important is that you have to know is that conciliation is a non-binding process. Now arbitration proceeding becomes binding, so that is a good part about the arbitration. But conciliation proceedings are not binding proceeding. It can only be reached mutually and agreed upon a settlement. Once you draft the settlement, this is the procedure. The procedure I'm talking about, that the conciliation will happen. The conciliator will sit across the parties, will try to make them understand. If they reach a settlement, the conciliator will draft the settlement for them. Both the parties will read the settlement, then they will sign the settlement, and then the conciliator will authenticate the settlement by way of his signature. That's when it becomes, binding. Once it is not, even then the recourse is that you're not happy with the conciliation, you can always go for other reliefs. So it's not that binding as an arbitration is. So also it doesn't, the number of arbitrators doesn't work like, number of conciliators doesn't work like arbitrators. Here only 2 presiding conciliators are needed. One is no issues. When there are 2, no issues. But if there are 3, then this third one will not be acting like a tiebreaker. The third will be just trying to push things forward. Then After you sign the agreement, it will get a statutory recognition. Then comes your uh, mediation proceeding. In the mediation proceeding, again, conciliation, as you see, it's more of a talking and making the person understand. Very similar form of you can say ADR is again mediation, which becomes effective in cases like matrimonial disputes or other matters where family dispute is there. So all these types of, because here, a mediator, which is a mediator is always given a training to um, see, conciliator can make them understand, arbitrator can hear the matter and then settle it, but a mediator has to have that skill of making the person understand. And it can be two ways. Either, like if you are talking about a matrimonial dispute, either you can bring the two people together, the two people who are not willing to stay together, want a divorce, whatever the dispute is, whatever the issue is, the mediator has to, it's not, the mediator cannot start taking sides. The mediator has to hear both the parties and can make up whatever mind they have, can judge the parties, but they are not supposed to disclose it. Okay, no, mediators are after all humans. They can judge the parties, that who is wrong, who's right. It's okay, but the mediator's job is, because once you start judging a party, the party who you are judging will lose faith on you. So a mediator has to be a very patient person who hears both the parties and then tries to mediate, tries to resolve the dispute. So the mediation is stated to be successful. It's not important that you have to bring the two parties to stay together, only then it can be called as successful. Mediation can be also termed successful if the two parties amicably try to settle. Like they want to take different paths, it's okay. They want to file for a divorce, it's okay. But instead of fighting it out in the court, go for a mutual divorce. So that is how it works. So this is what mediation is. Now in mediation there are certain things which is important, like I'll just go through some of them. Like when we mediate, we try to, our conduct should be like that because there are negotiating styles, and where we try to judge the clients, that which category they are falling. And once we are able to give a category to the person, then we know which way to adopt for them. For example, the dodgers, we call the dodgers, they do not like unpleasant encounters. They are they you can say that whenever something happens, they are discussing the personal events which led to their separation, they will just dodge that. Let's not go into it. We are not here to discuss all these happenings. I don't want to discuss it. I just want a divorce. So these people are dodgers. So when you face a dodger, it is advisable that you try to make them comfortable. The person is dodging because has some inherent issue that he doesn't want to disclose. So you have to deal with these people in a different way. You have to make them comfortable, try to bring them out of their cocoon, so that they are able to act. Because if they say that I don't want to discuss the issues, I just want a separation or something, then you will not be able to help them, because unless and until they can start talking, you won't understand what the problem is, and then you won't be able to do justice through their problem. So the dodgers are the most risky ones. You have to first make them comfortable, and then you can move on with it. That also works with your clients, where this type of client is coming, you have to deal with them. Then the dreamers are there. The dreamers are, they are willing to um, uh, make extreme concessions. Like, if we stay together, I'm ready to do this, I'm ready to do that, I can do everything, but I just want to stay. Or they can go in extremes. They are dreamers. They are not thinking that life is not like that. Life is not so ideal. Like, if, for example, like, if a wife is their wife is expecting that the husband is supposed to behave in this way, or the husband is expecting, but that is going beyond a certain level. Those are dreamers with high expectations. So you have to wake them up from their dreams, that life is not like that. So this is how you deal with them. Then there are hagglers. Hagglers are basically uh, they make changes back and forth. You have to pinpoint them, that they are not stable. They'll say, okay, yes, I will do this. So if the person says, no, I can't live with you because you do this, like, no, okay, I'll mend this. You just stay with me. So you have to see that here, if the person is saying that I will mend this, you just have to stay with me, that means he will not, once these two people are going to live together, he will not be following. So the hagglers are actually, they cannot stay at one decision at a particular time. They will just very quickly snap out of it. So once you've given them, if you have resolved their dispute and you've requested the other parties that at least go and start living with the person, you will see there is a change. You will realize they're going to be back after 7 days and say that this person has not changed. So those are hagglers. So for hagglers, you have to make them understand that it's not that you can snap out of it or make a promise which you are able to fulfill. Just don't make a promise just for the sake of making it, or for bringing someone back. Then the compromisers. Now the compromisers are never happy. So you also have to tell them that it's not okay to compromise for everything. That if the person is doing, it's okay, I will live with it. No, you have to make them understand, because once you're unhappy, the dispute will again rise. So that is how you have to deal with all these people. So the compromisers, you have to bring them up, that no, you are not supposed to compromise on this. Then our competitors seem to thrive in conflict. They have this aggressive behavior, which automatically, how did this happen with me? Or they try to control and dominate. Both the parties will be dominating. So the competitors, you have to settle them, that see, if you're in a marital relationship, it's not a competition. If you're not competing each other, you might compete in your respective fields of work, or in your, because see, competitors they compete not only in work, they are competing in everything. They're competing in whether I'm able to wake up before this person, whether I'm able to eat before this person, whether I'm able to leave the house before this person, or where, if there are children, that the children loves which parent more. So this is what competitors are. So I also have to recognize the competitors and then settle the dispute. Then problem solvers are the last we look forward to. Is they they try to find for agreement, that that if this problem exists, there has to be a solution for that. So for these people, the main that they are not sitting at peace until that problem is solved. So for example, most wives are problem solvers, that they have to be at peace. If the problem is not solved, they will not be at peace. So the problem solvers are, you have to make them understand that not every problems are meant to be solved. So there is more than life. And so this is how the entire mediation. So if I'm telling you these things only to make you understand that mediation, as it sounds, it's more than that. Mediation, a lot of things happened, a lot of criterias are taken, a lot of strategies are made before a person goes for a mediation. It's not that, okay, I will make two people sit before me and mediate. Mediation doesn't mean that. You also have to recognize what the person is, how the person is, and what is going to click. So once you are able to, then only the mediator will be able to solve the problem. Many people think that, okay, they will they will be able to, resolve the problem. But the fact is that once they face the problem, they realize that there is no end to it. So a mediation cannot be successful unless and until you recognize the problem and then move ahead with it. So this is what the strategy which has to be there. Then also there are certain negative mediation behaviors which the mediators need to avoid. One is arguing. Suppose if you get hold of a mediator who's arguing with the so in such a state, if the argument is going on between the mediator and the parties, so that is not a good sign. It is not going to lead anywhere. Then is analyzing. The mediator is not supposed to analyze, or analyze or motivate a person to do something. The mediator will have to try to bring out the person's inherent quality and see, a mediator cannot force two people to live together, because that is not the end of the life. Once they leave the mediator office, they have to settle it amongst themselves. So that is why the mediator will not be analyzing, but will be taking out the inherent quality. Then minimizing. You need to know when the emotions are coming out, and when you have to suppress the emotion, when you have to make the emotions come out. So if it is coming out a lot, then the mediator's quality should be to minimize it. Then interrupting is not good. Interrupting, whenever the parties are saying something, if you are asking them to cut short, it is not considered to be a good quality, because here you're trying to resolve the issue. Then telling them what to do. This everyone tries to telling them what to do means you ask them that from now on you are going to do this or that. Now this is, the mediator has to understand that this is not going to resolve it. So because you might tell them what how to behave with each other, but eventually the inherent quality which is in them will be helping out. So if a person is, two people are meant to be together, they are meant to be together, but not lead an unhappy life. So that what is a mediator also have to recognize and pinpoint and take it out, whether that these two people will be able to survive with each other or not. Then these are some of the also for that the body language and all these things matters. The mediator's inherent quality is also to keep silent. This is the art which has to be mastered by a mediator, that he has to be silent and not to interpret. So this is something which is which helps out, and if the mediation happens, then and if the persons are able to understand what is wrong or what is right with them, that helps in resolving the dispute. And the last one here is your lok adalat. Now lok adalat is a judicial proceeding, and this also uh, as the word lok adalat states, that it is called as a people's court. Now what happens is the the concept of lok adalat only came when, in order to minimize the dispute which is there between the people. So lok adalat is also now considered to be a very efficacious remedy which is helping out people, and the decisions of the lok adalat is binding on the parties, and there are certain types of cases which can be referred to lok adalat. They are like mutation and land cases. Compoundable means which can be where the settlement is possible. Compoundable criminal offenses, encroachment of forest lands, family disputes, land acquisition disputes, motor accident claims, and cases which are not sub judice. So all these types of claims can be taken before lok adalat. And if you consider the section 19 becomes very important, because it talks about various lok adalats and how at every level, starting from the national level to the state level to the taluk level, the lok adalats have to be established. Then the jurisdiction again is that, before moving, the lok adalat has to determine and arrive at a compromise or a settlement that the parties to a dispute, whether they are bowing down before the jurisdiction of that court. Then this is, and if a lok adalat is not able to decide a dispute, in other words fails in deciding a dispute, then the matter is again back to the court, just like other, because the same principle happens, that the matter can be referred to ADR. If the ADR fails, then the matter is back to the court at the same point of time. So this is what your ADR mechanism is. And in the end, I would only try to say that it actually depends on the mental element of a person, the mental attitude of a person. That if a person wants to finish off a dispute, will have to consider all this ADR, and only these ADR mechanisms are possible in efficaciously resolving a dispute. So that is what it is. So I'm ending my session with it. Thank you. Do you have any question?
Any questions from the participants? You can either unmute yourself and ask a question, or you can even drop your question in the chat box.
I can see a question regarding University Tribunal and grievance redressal. Now, the provisions are there that everywhere there has to be a grievance redressal committee, that the law provides that when the institution is being formed, there has to be a grievance redressal committee, and you can, submit your disputes to it, and then the committee is formed, and that committee goes through it and decides the matter. Now, that matter can be only binding till the department level, but you can also take it after that. I mean, that the same matter can be challenged in court as well. So it is binding till the department, but it can be challenged after that. Any other question?
Hello.
Yes.
Hi, ma'am. I just had a simple question with respect to your observations. Ma'am, what is your opinion as a practicing advocate over the appointment of retired judges as arbitrator? I think, like in cases of statutory arbitration, we have seen that as a practice, especially up North India. So, I mean, this was prominent during 15, 16, 17. Is it still prominent? And
yes, it is.
And how does it affects the whole idea of arbitration? I mean, like someone being in litigation and as a judge for over like 20 years, 30 years, and then he suddenly shifted to this informal in double quotes, but still an informal way of dispute resolution. Do you think that they do not?
I would actually, I'll be in a better position. I mean, I am in a better position to answer this because I'm going through a lot of arbitrations right now where the arbitrators are retired judges. Now, I have faced two situations where the situation went a little offhand because the clients were unruly. Like the opposite party, they tend to behave in a manner where which was a little demeaning for the judges. So in that case, the arbitrator always has a way of recording the the conduct of the parties and terminating the proceeding. So that will be taken up by the court then. But I would actually say that it's a very good thing where the retired high court judges are being appointed as arbitrators. But because you see, when you're working, who says that just when you reach the age of 60 years, you're all of a sudden not allowed to work, or your mind becomes, retirement is just an age, right? It's not that one day before you were working and the next day you are you won't be able to work. So if a retired high court judge is accepting the arbitration and giving the consent, is also giving the consent that is in a fit state of mind to work. So also, as I said, that arbitration proceeding it is just the venue and the informal part where you are sitting either in a drawing room or in a hotel room where you think that the area where you are a little comfortable, but that's it. The entire proceeding is as strict as the the courts. So if you talk about that, after the high court judge retires, it's a little demeaning for him to let the state of mind to bring him to an arbitration. It's not use of labor, taking use of the person's labor and the knowledge and using it somewhere. So he might be retiring from the court, but then his mind is active, he knows the law, and will be able to lower the burden of the court in this way. So I think both things happen. It's not that the clients do not become unruly, they do, but there is a way out also. The way out is terminating the mandate. Wherever you are seeing that the clients are going offhand, just terminate the mandate, recording the conduct of the parties, and that conduct will be later on viewed by the judges at the High Court and the Supreme Court. So that is how. I hope I'm able to answer your question. Any other question?
Yes, ma'am. It was like more of a, like I wanted to take an opinion, more of an
Yes.
answer. Thank you for that.
I hope I was able to answer.
Madam, I have one question.
Yes.
How far does this procedure of CPC apply to the arbitration proceedings?
It doesn't
RCPC.
apply. It doesn't
Okay.
apply. It's just that it applies in form. Like the procedures, the CPC is not directly applicable, but because it becomes very easy for the judge to, because CPC is already formed. Now, when on the first day of the session, the judge is trying to, frame out the rules and regulation of arbitration, it becomes difficult to frame each and every rule. So he makes a statement by way of a decision that the CPC, the form of CPC will be applying. It's not that the entire provisions will be start applying, but like the evidences are taking whatever the the rules of evidences of CPC that will start applying. So it will be like an example for the judge. It will not be applying directly.
Okay, that's why perhaps arbitration or proceedings are quicker as compared to CPC.
Yes. So it's quite flexible also.
Okay.
It's quite flexible, but because you have to have some example to, the judge cannot become a legislator overnight and frame all the rules of arbitrator.
Yes.
That will become very tedious. So that is why just the form of CPC applies.
Yes. Thank you, madam.
Any other question?
Well, if you allow me, ma'am, I wish to ask a follow-up question to my first question. Actually, my indication was not that whether judges are eligible or efficient to continue as arbitrators.
Okay.
But my point was, see, as you very rightly pointed out during the session, that arbitration is different than litigation. So arbitration has to be less formal. The idea of whole arbitration, even domestic arbitration, actually I specifically deal in international commercial arbitrations, but even domestic arbitrations, because they have much effect, especially with respect to judicial intervention in international commercial arbitration, or for that matter, any international arbitration, being investment or commercial. So judges sit in these such arbitrations. Do you think, like with that, they also, like with their experience, they also bring the procedure of court into arbitration?
Okay, so I understand what you're trying to say is that
One more.
instead of making it informal or an efficacious way, that it becomes a little with the judges knowing the law so well, and they'll be fulfilled with technicalities, so it loses its purpose. I
Yes,
think
yes.
the question is that you are rightly saying that, because what we are saying is also with judicial intervention. Now section 8 and 9 is very clear that okay, only these sections are can allow judicial intervention. But then what is happening is, because of so many cases coming up, because of so many technicalities, it actually, that is why I'm saying now that arbitration has actually gone on the days when it was a simpler process. Now it becomes very because now even if the judicial intervention is not there, it is there, you cannot deny the fact. So that becomes very technical, and that is why arbitration can take away the load, and it is effective only that the mandate of 1 year is there, that you are maybe that the process, if you file a case that will take 7 years, 8 years, 20 years, so you are shifting it to like 1 year. So I think the only relief is that. Apart from that, yes, I still think that it is way more technical. It is, as I said now, I gave the comparison that civil suit only 3 steps are there, arbitration so many steps are there, and if you accept or not, judicial intervention is there, so it becomes technical. I am agreeing with you here. But it's not because of the retired high court judges, but because, see, if it is only because with the passage of time, as the law is developing, so many case laws are coming out, and Supreme Court and High Court are intervening at every step. That, for example, suppose now, as the Vidya Drolia case, it states that before you file an application before the High Court, you have to produce the arbitration agreement, the original arbitration agreement. So many laws are coming out. So that those laws which are forming precedents, those precedents are making it very cumbersome. So I won't blame the judges. That thing is a little there, but I think it's only because of the technicalities and the laws, not because of the judges. Because I have myself has attended proceedings, the judges are not like that. It's not that they are having those airs and everything. So it's only the technicalities which are making it cumbersome.
Thank you for sharing your experience and answering my question, ma'am.
Any other question?
No, ma'am.
Thank you so much.
Thank you, ma'am.
Any more questions from the participants?
No, ma'am.
Thank you, ma'am. Thank you.
Thank you, ma'am.
My pleasure.
So thank you so much, ma'am. I think there are no more questions from the participants. So thank you so much, ma'am. It was a wonderful and an insightful session. And thank you so much for taking out your precious time for us and the participants as well.
Anytime. Thank you for having me.
Thank you so much, ma'am. It was our pleasure indeed.
Shall I leave the chat, the group?
Yes, ma'am.
Thank you. Thank you.
Ma'am, thank you.